Test, test. All right. Okay. The committee will come to order. I want to remind members that opening statements were yesterday, and of course, all members are able to submit their opening statements. And at the conclusion of that yesterday afternoon, the chair did call up H.R. 2666, and the bill was open for amendment at any point. So let me ask this question. Are there any bipartisan amendments to the bill? Don't see any. So are there any amendments to the bill? Don't see any. So the question, gentleman, I'm sorry. Gentleman from California, Mr. McNerney, has an amendment at the desk. Clerk will call the title of the amendment.
Amendment to H.R. 2666, offered by Mr. McNerney. And at the end of the bill, add the following.
And the amendment will be considered as read. The staff will distribute the amendment, and the gentleman from California is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. This is a very, very simple amendment. Nothing in this act shall be construed to affect the authority of the Federal Communications Commission to act in the public interest, convenience, and necessity. This is basic. This is what we want. The public interest is a key principle that the Commission has used to protect consumers since Congress first created the agency in 1934. It's just as important today. The FCC has consistently looked to the public standard when taking action to protect consumers, foster innovation, and increase competition. That standard has been the hallmark of the most important policies the Commission has undertaken. To give you a sense, the words public interest appears 93 times in the Commission's Act. That's how pervasive this concept is. This amendment would seek to limit some of those unintended consequences by ensuring that the Commission continues to have authority that historically served it so well. Moreover, by preserving the FCC's authority to act in the public interest, my amendment would safeguard the broad aims of the Communication Act, and this amendment would continue to appropriately focus the FCC toward promoting the public good. I urge I urge the members to support it, and I yield back.
Gentleman yields back. Chair will recognize the chairman of the Telco Subcommittee, Mr. Walden, for 5 minutes.
Thank you very much, Mr. Chairman. I speak out in opposition to this amendment. Appreciate the gentleman's offering it, however, and his concerns. The issue here, though, if you go with his amendment, you basically vitiate the rest of the bill. you do away with the whole concept on this, because there's no fence around the term of public interest obligation. It is whatever the FCC at the time says it is. And part of what we're trying to do as the policy setting body for the Federal Communications Commission is establish some definitions, establish some boundaries, give some certainty to the marketplace as to how things are regulated, what's regulated, and try to get to a predictable point where we can stimulate innovation and technological growth. Remember, what's really going on here for the first time is that through the Obama administration to the FCC, the order went down to treat the internet as if it's an old railroad or canal system or common carrier in the communications law, and begin to regulate something that has been one of the most vibrant, job-creating, innovative things in our lifetime, in the history of humankind probably, and that's the internet. And what we're trying to do is say, now wait a minute here, we'll be with you to stop the bad behavior, blocking and throttling, and maybe even paid prioritization of things I think we could find common ground on legislation, although we've not been able to get any support on that from the other side of the aisle. Meanwhile, the courts are going to decide what the FCC can or cannot do in terms of Title II regulation. But what we should do with what we can deal with here is to say, no, there are boundaries. If you just go back to the public interest obligation statute, there's no definition of what that means. It means whatever the majority, 3 people at the FCC, decide it means at the time. That does not give certainty to the marketplace. That will diminish innovation and job creation in America. And so therefore, reluctantly, I disagree with the gentleman from California, and I'd urge my colleagues to oppose his amendment. And I yield back the balance of my time.
Gentleman yields back. Other members, gentlelady from California is recognized.
Thank you, Mr. Chairman. I support Mr. McNerney's amendment, and I think that it is an essential one. There needs to be, I don't know how many members have actually gone back to read the Communications Act, which is really what moving forward over all of the years was at the heart of the Communications Act. So there are the laws. In the Communications Act, the words public interest appear 93 times. 93 times. And so this isn't a new notion. This isn't using 2 words to throw sand in the gears. I think that public interest is already established, and it needs to be kept, and I think it needs to be honored in each generation in terms of the work that we do. It's foundational. It's foundational. And so I think that the gentleman's amendment makes eminent sense. The public interest is the key principle that all the commissions have used to protect consumers since the agency was first created by Congress going back decades. And it's just as important today. It is just as important today. I mean, you can compare or just use the, you know, on the one hand, people can say, well, the Constitution is dusty, and so you just disregard it. And that the Communications Act is dusty. In each generation, there has been an adherence to the basic principles and values, and as I said, 93 times this phrase appears in the Communications Act. So what the gentleman is putting forward is, again, something that is foundational and that we should be honoring just as much today as we have in the past. So I support it, and I yield back.
Would the gentlewoman yield?
I'd be glad to.
I just want to support the amendment as well. I think it's a pretty sad day when we have to argue over language which says that the FCC should act in the public interest. I mean, it's it seems to me that's so obvious that it's amazing to me that we're actually debating it. And so I appreciate the fact that the gentleman offers this amendment. I don't see how anyone can justify not supporting it, so I would urge my colleagues to support it. I yield back.
Gentleman yields back. Other members wishing to speak? Gentleman from Illinois, Mr. Shimkus.
Thank you, Mr. Chairman. I think this is instructive to just on our citizens are asking who makes the laws. And I think I would rather have elected officials determining the public interest than appointed bureaucrats. And I think, you know, if we're asking why this is important is because that issue. I think people want us to be more specific in the legislative language, and the Constitution in Article 2 gives the power of the executive branch to enforce that. Not to determine, not to make up, not to change, but to enforce the laws of the land. So I'm going to support my colleague and friend, Mr. Walden, and ask for a no vote on the amendment. I yield back.
Gentleman yields back. Other members wishing to speak? Seeing none, the vote occurs on the amendment offered by the gentleman from California, Mr. McNerney. All those in favor will say aye. Aye. All those opposed say no. No. Opinion of the chair, the noes have it. The amendment is not agreed to. Are there further amendments to the bill? Seeing none, the question now.
Mr. Chairman,
Oh, I'm
I have an amendment at the desk.
The clerk will report the title of the amendment.
Amendment to H.R. 2666, offered by Mr. Walden.
The amendment will be considered as read. The staff will distribute the amendment, and the gentleman from Oregon is recognized for 5 minutes in support of his amendment.
Thank you very much, Mr. Chairman. I offer this amendment to address the concerns expressed during the subcommittee consideration of H.R. 2666. Now, in that markup session, our colleague, Ms. Matsui, offered an amendment that proposed a number of exceptions to the no rate regulation rule. Among them were concerns the bill would prevent the FCC from using the Universal Service Fund rules to ensure comparable rates between urban and rural areas, concerns that this would authorize paid prioritization, and concerns that the FCC would be hampered in enforcing its truth in billing rules. I listened to Ms. Matsui. I thought her comments made a lot of sense, and this amendment clearly addresses those particular items that Congresswoman Matsui raised during the subcommittee markup. I appreciate her always constructive role on this important subcommittee. Now, unfortunately, we could not reach agreement on some other elements of her amendment. The amendment offered at subcommittee asked us to give the Federal Communications Commission authority to act to regulate discriminatory practices and, quote, to act in the public interest to protect consumers or regulate the billing practices employed by or penalties or fees charged by providers of broadband internet access service. Now, while these statements all sound good on the face, in the hands of the Federal Communications Commission, they would actually reverse, the practical effect is they would reverse the no rate regulation purpose, which is the purpose of this measure. If we were to accept these provisions, in fact, we would tell the Federal Communications Commission, don't rate regulate unless you think it's a good idea to rate regulate. So that would be inconsistent with the underlying purpose of the bill, inconsistent, by the way, with the President of the United States' own statement, and inconsistent with Chairman Wheeler's repeated statements to us and to the public. Post facto rate regulation is a dangerous regulatory weapon that will threaten competition and innovation in the rapidly evolving internet marketplace and thereby reduce consumer choices. What we were able to achieve is an amendment that addresses the concerns that we share. The language in my amendment, Mr. Chairman, ensures the FCC can continue its ban on paid prioritization, can continue to ensure comparable rates between urban and rural customers, and can continue to enforce its truth in billing rules. Those are all protected by this amendment. I believe these are important consumer protections. I believe we all can embrace them. Throughout the drafting of this bill and our amendment negotiations, our guiding principle has been to codify the bipartisan agreement expressed by President Obama, Chairman Wheeler, members of this committee, and the Senate Committee on Commerce, Science, and Transportation. The changes proposed in this amendment improve the bill and further that goal. I urge my colleagues to support this amendment and the underlying bill. And so with that, Mr. Chairman, I would yield back the balance of my time.
Gentleman yields back. The chair would recognize the gentleman from New Jersey, Mr. Pallone.
Mr. Chairman, I can't support the amendment offered by Mr. Walden. We have an unfortunate pattern developing in our committee, and I think it's important to note it now, Republicans claim they're willing to consider our concerns, but it has become apparent that such consideration is dependent on the Republicans doing it for us. This amendment doesn't effectively address Ms. Matsui's concerns. On this bill in particular, almost every time the Democrats have dared to provide specific written concerns ourselves, the response from our colleagues across the aisle has been a resounding no. To be clear, we had no hand in the drafting of this amendment to supposedly address our issues, and in my opinion, this amendment is just another example of the folly of this partisan approach that we're seeing today. I yield.
Will the gentleman yield? Will the gentleman yield?
Well, I'll yield first to Mr. Green.
Thank you for yielding to me. My concern about both these bills today, and I agree with you that some of these things we could deal with, particularly on this bill, but there's no cross the aisle working together on it. And that's unlike what we did last year with a lot of our bills last year in the odd-numbered year that we had. We worked on cures, worked on a lot of different bills that had bipartisan support. And particularly on this bill, I think we could probably get to bipartisan support. I have to admit, on the health care bill, we couldn't get there with what the cuts are. But I hope our committee's not going to consider doing this for the rest of this year, because it'll make it a really difficult session for us, simply because if you come out with only Republican votes, it may pass the House floor, but it'll never get past the Senate. And if you want to actually legislate, we need to have folks talking across the aisle. And thank you for yielding.
Would the gentleman yield?
Certainly.
Because I just want to call this for what it is. First of all, let's talk about a bill that passed out of this committee after bipartisan negotiations, very productive ones. The Small Business Exception Bill for the FCC on the reporting requirements on internet. We met, we had disagreement at sub, we worked with the Democrats, and guess what? We came out unanimously. Unanimously out of this committee, probably passed unanimously on the floor. The FCC Process Reform Bill, bipartisan bill, we worked out our differences, came out of this committee. The .com Act, bipartisan bill. Our staffs actually worked quite closely together on that one as well. The Consolidated Reporting Bill, FCC Process Reform and Consolidated Reporting.
Well, let me just
came out of this committee
let me just take
bipartisan.
back my time,
So let's at least be honest about
Let me take back the time. I'm not
bipartisanship.
suggesting, Mr. Walden, that we didn't work together on those other bills. I appreciate the fact that we worked together. The point I'm trying to make is that we did not work effectively on this bill. I don't want to give the impression that your amendment addresses the concerns that we have that were in Ms. Matsui's amendment. I think you made it quite clear in your statement earlier that it doesn't. Maybe it addresses a few things, but it doesn't address most of it. And I think Mr. Green's point is quite apt. He's basically saying that if we want to actually get a bill that's going to pass the House, pass the Senate, be signed by the President, we need to do a lot more work on a bipartisan basis. I'm not arguing about what we've done in the past on the other bills. I agree with you, but I think that it's quite clear that we're not making progress on this one, and that we shouldn't have had the markup today because it's not going anywhere. That's my only point, and that's why we're going to be offering the amendments from Ms. Matsui as well as Ms. Eshu, because we're not there, and I just don't want to give the impression to our Democratic colleagues that we are. We're certainly not. If you want to add anything else.
Well, I appreciate the gentleman's clarification, because I was trying to, in my own statement, be very clear that we were able to reach agreement on at least 3 of Ms. Matsui's concerns. The others, I said very clearly, we couldn't find common ground on. That's kind of the legislative process. So
I
appreciate
understand.
your admitting
I
that.
don't disagree with you. Let me take my time back. I don't disagree with you. I'm simply saying that I think Mr. Green is right. We can work further and come up with a consensus bill on the points that Ms. Matsui and Ms. Eshu raises, and I just hope that we do. We're certainly not there yet. And with that, I yield back.
Gentleman yields back his time. Other members wishing to speak?
Mr.
Let me
Chairman?
go on this. Mr. Kinzinger is recognized for 5 minutes.
Thank you, Mr. Chairman. I just want to say thanks to Chairman Walden for offering this amendment today. I've said many times before, the intent of this legislation is simply to ensure that the government's not in the business of mandating what rates consumers are going to pay for broadband. Very simple. Time and again through this process, we've heard the argument that the language in this bill as it stands, might have unintended impacts in other areas of regulation. For example, when Harold Feld was before the committee, he specifically mentioned billing practices and the Universal Service Fund. We took those concerns to heart. Additionally, during our subcommittee process, some more areas of concern were mentioned. Just to ensure clarity of argument, I'm going to read a small outtake outlining the arguments from the transcripts of that subcommittee markup. It was stated, quote, "The bill is far broader and could eviscerate the FCC's authority to protect consumers against truth in billing practices, discriminatory data caps, to ensure that broadband availability through the USF and E-rate are protected to address rate-related issues, and merger reviews to ensure enforcement against paid prioritization." Those are all legitimate concerns. So let's take a look at what's in this amendment. Number one, nothing in this act shall impact the authority of the commission in regards to the Universal Service Fund. Cool. Nothing in this act shall impact the authority of the commission in regards to truth in billing. Awesome. Nothing in this act shall impact the authority of the commission in regards to paid prioritization. Straightforward. For the purpose of this act, broadband internet access service shall not be construed to include data roaming. Excellent. For the purpose of this act, broadband internet access service shall not be construed to include data roaming interconnection. So as you can see, this amendment not only clarifies that the bill before us would not touch those areas of concern, but we actually go even further to ensure that the intent of this legislation moving forward. We really want this legislation to be bipartisan. And I appreciate working, our staff and leadership and everything, working with the other side of the aisle. It's been great. But in a negotiation, neither side necessarily gets everything they want. We had 5 areas of concern that were offered. We have 3 of them in there. I mean, this is a strong move to bipartisanship. But the idea that bipartisanship becomes totally capitulate to my side, which is what I'm hearing, is just unrealistic. So I want this to be bipartisan. I hope it is. But, we'll see. I think it's important to note, too, lastly, Ms. Matsui, and I appreciate having worked with her, but the universal service with her concern, truth in billing, interconnection, those are all in here. So it may not be everything, but it's a really good step to bipartisanship. So if nobody wants to speak, I can just yield my time back. I yield back.
Gentleman yields back. The gentlelady from California, Ms. Eshu.
Thank you, Mr. Chairman. I'd like to ask we didn't see this amendment until maybe 2 hours ago. It was introduced, or we saw it this morning. So I'd like to ask some questions of the council relative to the definition of rate regulation. Can you briefly describe the way that that this amendment actually defines rate regulation?
This amendment defines the term rate as the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. The bill also defines broadband internet access service as the meaning given such term in the rules adopted by the FCC as part of the Open Internet Order. The term regulation is defined as regulation or regulate means with respect to a rule, the use by the Commission of rulemaking or enforcement authority to establish, declare, or review the reasonableness of such rates.
And where did this definition come from? Is it a definition that is used elsewhere in the law?
The definition of broadband internet access service is used elsewhere in the law. The definitions of rate and regulation are for the purposes of this act.
So it essentially rests on the definition of broadband and what you just described, not anything else.
All 3 of these definitions work in conjunction to define the scope of the bill.
Just on broadband. Now, are you aware of the definition of rate setting the Supreme Court recently adopted? The Federal Energy Regulation Commission versus Electric Power Supply Association?
I don't have that in front of me now.
All right. Well, I think that I think it's important to draw from, and I don't think it has happened, where you choose not to use tested Supreme Court definitions rather than writing your own definition without any legal vetting. I mean, we are writing a law. This is a markup. This is not just it's an important debate, but we're writing a bill. So these are very important tenets, I think, that need to be honored. Now, in the description from our friends in the majority, and I want to thank you for where you have moved to. You have moved. You've moved somewhat. You've moved somewhat. But data caps are not in this. Merger reviews are not in this. FCC transparency are not in this. And general conduct standards of the net neutrality rule are not in it. Now, maybe you think these things are a pile of junk. I don't know. But they are, they are very important elements. So I agree with our ranking member.
Would the gentlelady yield on that?
Just a moment. I just want to finish, and then I'd be glad to. I don't think that this effort is ready for prime time. I really don't. And I want to make something very clear, and that is that the Democrats are not for rate regulation of the Internet. We are not. And that's why I offered before, I will offer again, the amendment that codifies exactly what the majority has been saying all along. Where we somehow have hit the ropes is that we're starting to get into, well, we'll allow the FCC to do this, but we won't allow the FCC to do that. And I think that that's skating on thin ice. I really do. I don't know where the FCC has gone so wrong on data caps, on merger reviews, on transparency, on the general standards. So I think this needs some more work. And I hope with more work that we can come to an agreement. So with that, I'd be glad to.
Would the gentlelady yield?
I'd be glad to yield the remainder of my time to the chairman of the subcommittee.
I appreciate that, the gentlelady, and I appreciate her comments. Nearly everything that you raised of your concerns that's not in here, they're not in there because the authorities continue to exist under the Federal Communications Act, under the Open Internet Rule, to continue to regulate. We didn't address any of those. So, because I know you support the open.
Let me ask you something. I'm not a lawyer, but
That's
are you?
No.
No, good.
That
Okay.
usually gets a round of
So
applause.
it comes from the same starting point. When under the your amendment's definition of rate regulation, does that include what I mentioned, even though you don't mention it in your amendment?
Could you read me the list again? So we get
Data
this right?
caps, merger review, FCC transparency, general conduct standards, you know, the net neutrality rule. Are those all just assumed and covered under your new definition that the council just read?
So mergers, I'm told, has been outside the bounds for 25 years, and so we don't address that. What were the other ones? I'm sorry, we can kind of go one by one.
Data caps, merger review, FCC transparency, general conduct rules.
They would not be allowed to regulate data caps under our bill. That's true. The transparency rule stays the same.
Well, see,
We don't address that. But so
we're over our time. I don't know if anyone wants to yield.
Could we ask
I was
Ms.
letting you
Castor-
be. I was letting you be constructive. So
Keep going.
Thank you, Mr.
till
Chairman.
it digresses.
See, I think that this is where the problem is. First of all, the amendment was filed a couple of hours ago. So we're asking questions to find out what's in it, what does it bump into, what does it protect, what does it leave out? And I don't know if anyone on this side is really fully cognizant. I can't answer those questions.
I think we can address them.
I think that you just attempted to, but that's why I think this needs more work. I sincerely mean that, and I think that you and I need to sit down and talk, Mr. Chairman, and not
Happy
just
to.
our staffs.
Anytime. So I think we can address each of those issues and have with our legal counsels. Second, our amendment was filed approximately the same time all amendments are filed, well within the rules, 2 hours.
Well, I was criticized for filing something 36 hours ahead of time. Now we have a new standard, so, you know, it came in under the wire. The point is not
that was
the
a much
hour,
difference.
but the knowledge. You
Happy
see?
to give it to you.
Yeah. So that's why I'm asking the questions, and I would just ask you directly if you can postpone this, and that we take another stab at this to see if we can come to a meeting of the mind, of our minds. You know, I think it deserves that. If not, then we'll proceed. But that's what I would ask in all sincerity, and see if we can reach an agreement.
Well, I'm always open to sitting down, talking. As you know, I'm always open. Our side is to negotiating these things. When issues have come up, like Ms. Matsui raised 4 or 5 issues, we had that discussion, didn't agree to everything that she had concerns about, but this is a legislative process. 3 of them are, I think, addressed appropriately here. On some of these issues, we just have a disagreement. This bill was filed a year ago. We've had the due process of hearing on it in subcommittee, markup on it in subcommittee. Now we're here to mark up on full
Well, I
committee.
think reclaiming
And
my
so
time. I think it's my
well, I don't know
time,
who's
isn't
got
it?
the
Yeah,
time.
reclaiming my time.
Time is
it?
now expiring.
Expired.
However,
Okay.
let me just say that I would encourage both of you to perhaps, as you suggested, sit down together. It's going to be a while before this bill gets to the House floor. If you're able to reach a further accommodation on an amendment that addresses the concerns that not only Ms. Matsui raised earlier, but now, I certainly would be willing to help urge the Rules Committee to allow such an amendment. And with that, gentleman's time has expired. Is anyone on this side? Going back to the other side, gentleman from Pennsylvania is recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to strike the last word and oppose this amendment on the underlying bill. As has been discussed, that this amendment was filed this morning, so we've had very short time to read the text or discuss the full ramifications of the language with the FCC or any other expert authority. But in the short time that we have had to look this over, I can tell you that I have grave concerns about it and the underlying bill as well. You know, at the subcommittee markup, there seems to be some misunderstanding between our two sides about what opposition to rate regulation means. To be clear, what I mean is that I do not support ex-ante regulation, which is what the FCC explicitly prohibited in the Open Internet Order. I, along with many of my colleagues, agree with Chairman Wheeler and the majority of the FCC that they should not be in the business of explicitly setting the cost of broadband service, nor should they be in the business of explicitly approving or denying rate changes. What I and many of my colleagues on this side of the aisle do not agree with is this legislation and this amendment's attack on the FCC's ability to enforce the Communications Act and its own rules. While I appreciate that this amendment carves out universal service, truth in billing, and paid prioritization, I believe that it puts at great risk the Commission's enforcement authority, its ability to evaluate mergers, and its ability to act in the public interest. One of the most notable carve-outs, not in this amendment or the underlying text, is the one for the Open Internet Order. This omission would seriously endanger the FCC's ability to evaluate zero rating programs, enact or enforce any forthcoming rules to protect consumer privacy, or enforce the Commission's general conduct standard. These rules are intended to protect consumers and the vibrancy of our innovative and competitive online economy, so it's unacceptable that this amendment and the underlying bill would undermine them. This amendment does not address the underlying harms this bill will do to the Internet ecosystem or the American people. Therefore, I cannot support this amendment, and I encourage my colleagues to do the same.
Would the gentleman yield?
Yes, I will.
I appreciate it. I would ask the gentleman, do you support things like the Binge On initiative from T-Mobile?
We have some concerns about that.
You have concerns about it, okay. The reason I raise that is by all estimates, some 34 petabytes of data have gone through that program so far, saving consumers maybe as much, these are just rough estimates, $100 million. Consumers are actually getting a choice here on Binge On, and I'm not advocating T-Mobile or anybody else, but I'm saying this is the kind of innovation in the marketplace that consumers are going to and it's saving them money, that the FCC has said, well, maybe this is okay, but you know what, we're going to take a look at it too. And we may come back and say it wasn't okay.
But
and so I'm trying to get to where the
But Greg,
consumers
there's a
are
lot of providers that aren't in this. YouTube's not in it. Facebook's not in it. I mean,
by
I think
choice.
I think what this boils down to really is whether or not you believe the FCC should have the ability to enforce
if the
its own
gentleman
rules.
yield, Facebook, I believe, is doing a free data process overseas and here too. I mean, the companies are innovating. That's why I don't understand the objection to stopping the FCC from post facto rate regulating by coming back on them or T-Mobile or somebody and saying, you know what, it wasn't really fair, so now we're going to come back and punish you. That is what suffocates innovation in a vibrant marketplace that heretofore has not labored under the heavy hand of government regulators.
Listen, this is to make sure that ISPs aren't picking winners and losers. Okay, that's what this is about. I just think, and the bottom line is this, is either you believe or you don't believe that the FCC should have the ability to enforce its own rules, act in the public interest, approve or deny mergers. That's not just rate regulation. That's the commission doing its job. And if you disagree with that's fine, but we don't.
Would the gentleman yield?
And I'll yield to Ms. Eshu.
Thank you, Mr. Doyle. I just wanted to add something to this, to Mr. Walden to consider. If the provisions that are left out of the bill won't be impacted by the bill, why not just say so explicitly? I just put that out there because I think it's an important thought if, in fact, we get to sit down and talk about this and put this off to another day and see if we can come to some kind of an agreement. We may have too much of a chasm, but I think we should try.
Gentleman's time has expired. Other members wishing to speak on the amendment? Gentleman from New Mexico.
Thank you, Mr. Chairman. And my question is to the General Counsel. I apologize, some of the questions may be the same that I asked in the subcommittee markup. I think that there's a different General Counsel in the chair today, so I apologize if some of this is redundant. But my questions follow up on Ms. Eshu's question about the definition of rate specifically. Can you tell me where the definition that is included in the amendment comes from?
This is a definition that was drafted for the purposes of this amendment.
So this definition was drafted for the purposes of this amendment. Were there reference materials that were used for the drafting of the definition of rate in the amendment?
Yes, in the process we looked at different definitions used in different contexts, including different court cases.
Can you tell me which court cases you used?
I don't have the citation with me, but one of the cases was the Supreme Court's decision in Hope.
If the gentleman would yield,
I would yield.
Since it was really an elected official that helped write this definition, that'd be me, with the support of council, obviously, because that's what we do here is we write law, we define things, and that's what we're doing here. And we did look at the FPC v. Hope natural gas case, which, as you know, having been a regulator, sort of set the standards for what rate regulation and tariffing is. It's a 1944 case from the Supreme Court. I appreciate the gentleman yielding.
I appreciate the response from my chairman. As we look at the case from 1944, there's been a lot that's been derived from how rates have been treated. Having the honor of serving on a regulatory body in the mid-2000s, sitting before different rate proceedings, we've been in front of that. Ms. Eshu asked specifically as well if the council was familiar with the more recent rendering by the Supreme Court with the Federal Energy Regulatory Commission versus Electric Power Supply Association. Are you familiar with that case?
I'm not, and I do not have the case in front of me, so I'm not.
Was that case used in any way to look at the definition of rate, since it's more updated from 1944? I yield to anyone.
No, because this is an issue of first impression.
Appreciate that. Not being an attorney, I appreciate that.
And just one other note, by the way, the Communications Act is from 1934. So it's actually 10 years older than this court case. But this court case fundamentally set the rate of how you determine a rate of return and all of that, as you know, in the R equals 0 plus V minus DR.
Appreciate that, Mr. Chairman. And my question to council again is, last time I asked if you all used a dictionary. this is an old version, maybe published in 1944, of a dictionary. Today, you can go online, and Webster's has a simple search engine derived by Yahoo or Google or just about anyone else. You can get to Webster's. There's various aspects of the term rate that's defined inherently therein as well. All that I'm saying here is, with the complexity associated with how this term is going, and did council use the definition of the dictionary?
We considered various definitions of the word rate and drafted a provision that we think best reflects the intent and purpose of this
Okay.
bill.
And real quick, Mr. Chairman, if I could just ask one other question, because this gets to the specificity associated with the definition that's used. And I appreciate that there was an attempt made as well to define this. I think we need to get closer to defining rate as well. But my concern is this: as we look at rates, inherently with all aspects associated with charges, can council guarantee me that paid prioritization is not impacted by this definition of rate?
This amendment explicitly has an exception that says nothing in this act shall be construed to affect the authority of the commission to enforce Section 8.9 of Title 47 Code of Federal Regulations, which is the codification of the FCC's paid prioritization rule from the Open Internet Order.
But then the definition of rate goes on to say anything charged for internet services. So anything charged for a service is inherently all the costs and all the inputs into what's going to be charged. So if there's an aspect here with how vague we are with these definitions, that's our concern here. And
Well,
look, in
will the
the
gentleman
end,
yield?
real quick, Mr. Chairman, just one last point, I'll yield to you.
Yeah.
Ms. Eshu offered an amendment during the subcommittee markup that would have codified the FCC's order that we all say we agree with. It would have put that into this definition. It would have put it into law. It would have made clear that, as Ms. Eshu made very clear, the Democrats do not want there to be rate regulation, tariff regulation, charge regulation, whatever it may be, with the setting of paying for internet services by the FCC. Let's be clear about that. But Ms. Eshu's amendment would have done that. And so with that, I yield to the chairman.
Gentleman's time has expired. Chair would recognize Mr. Shimkus.
Thank you, Mr. Chairman. I yield my time to Mr. Walden.
I thank the gentleman for yielding. Let me, because I know my friend from Mexico ran out of time, and so let me respond to a couple of points. First of all, let me set on the record that the Republicans did not fully embrace in its entirety the open internet order from the FCC. So that's a bit of an overstatement from that. What we do oppose is blocking and throttling and paid prioritization and the offensive things. We did not support the Title II common carrier regulation, take the internet backwards into when we regulated canals and railroads and telecommunications, electric grid. So let me clarify that for the record. I know he didn't mean to overstate and drag us into something we're not a part of. Second, this is what we do is define things. We do it all the time here in Congress, and what we're doing here is defining a rate means the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. We did look at other legal sites. We did look at other legal precedents in coming up with this definition. And so, I mean, it is what we do here. And so I think it's reasonable. What we don't want, and I would hope that you would agree with me on this, what we don't want is a commission, either this one or a future one, that has post facto penalty rate regulation, where you have innovation in the marketplace like I cite with Binge and other companies, and then an FCC, including this one, that is saying, well, we're going to take a look at that. It's out in the market. It saved consumers maybe $100 million. I don't know the number for sure. That's a big ballpark estimate on our part. But given the amount of data and kind of the data rates, we did an estimate. But the long and short of it is consumers are making the choice, not the regulator. But the regulator could come back and say, well, gee, you didn't ask Mama, may I? But then you didn't really have to. But we can come back afterwards and said, hey, you went afoul. And that's the thing we're trying to stop here and define it. And maybe this FCC won't go down that path, but there's no guarantee the next one won't. And so I'm not a fan of a big, heavy FCC regulatory arm, 3 people, really 1 chairman, whoever that is in the future or today, that can come in and decide the whole fate of the internet and snuff out innovation and the kind of technology we've seen. Because remember, we've gotten here without Title II regulation. We've gotten the innovation, the jobs, the technology, the consumer choice without mother may I, or gosh, did I make a mistake, or I thought it was okay, and then they come back and whack you. And that's what we're trying to avoid. You want to join with us? I've had draft legislation for more than a year open to the Democrats to join us to simply block paid prioritization, blocking, throttling, the things where we do find common ground. I'd welcome you to be a part of that. We can't go as Republicans all the way to Title II regulation and government intrusion in the internet. We will be with you on stopping the bad behavior and punishing it, no question, clear. But now you're going to have a court case that may well decide it's okay to regulate on the hardwire side, but not on the mobile side. That may well be the outcome. And then what kind of internet are you going to have in terms of regulatory environment when we're all going mobile? And so I wish we could find common ground on this other point, but so far no takers. So
Would the gentleman,
it's my time.
I yield to my friend from Texas.
Gentleman's from Illinois.
Yeah.
Oh, I'm sorry. Yes, I yield back.
I've tried not to get too involved in this debate, but at some point in time, you just have to kind of tell the facts are the facts. This is a one-sentence bill. One sentence. All you got to do is read the bill. It says you're not going to regulate the rates charged for broadband internet. Why do we have to have the bill? Because the Obama FCC has bent over backwards to try to figure out a way to get regulation of the internet. And they did it through this order, and so the chairman of the subcommittee, with the support of the full committee chairman, has introduced a one-sentence bill that a fourth grader can understand. And I was here in 1996 when we passed the Telecommunications Act that created what today is called the open internet. And we consciously made a decision that we weren't going to have any kind of rate regulation, and that has worked until this FCC has taken it upon itself to try to shoehorn regulation into Title II, the 1934 Communications Act, when we had a monopoly in this country of hardline telephone service. This is a simple bill. We should all vote for it. And then in the next administration, if we need to go back and clean it up, let's do it. But I strongly support the bill. I strongly support the amendment because it is an attempt by the subcommittee chairman to adhere to some of the issues that the minority raised in subcommittee and in earlier amendments apparently this morning at this markup. It's that simple.
Would the gentleman yield?
Gentleman's time has expired.
His time has expired.
Other members wishing to speak on the amendment? Seeing none. The vote occurs on the
Yvette
amendment.
has
Oh, I'm sorry. Gentlelady from New York is recognized. Strike the last
Thank
word.
you, Mr. Chairman.
Pardon.
My Republican colleagues have offered this amendment, and it would preserve the FCC's authority over some policy issues with regard to consumer protections. This amendment only singles out subpart Y of Part 64 of Title 47 of the Code of Federal Regulations. I'm concerned with the FCC's critical consumer protections that they've been omitted from this amendment. Counsel, could you tell us whether the Communications Act or FCC rules specify any other consumer protections?
Could you clarify the question, please?
Yes. According to this amendment, we're looking at singling out subpart Y of Part 64 of Title 47 of the Code of Federal Regulations. And the FCC has a critical role in consumer protection, so I was wondering if you could tell us whether the Communications Act or the FCC rules specify any other consumer protections.
The Communications Act does contain other provisions that are related to consumer protection. This bill only addresses the regulation of rates as defined by the bill.
But do you know whether it includes the truth in billing provisions of subpart Y of Part 64 of the FCC rules?
This bill this amendment explicitly carves out those rules, the truth in billing rules codified at subpart Y of Section 64 of the 47 CFR.
Well, given the way that this amendment codifies the FCC truth in billing rules, would the commission be able to amend these rules in the future, or would these rules be frozen in time by statute?
This would codify, or this would accept anything codified at that portion of the CFR?
So frozen in time?
No, as long as they are codified in that subpart Y of Part 64 of Title 47 relating to.
Will the gentlelady yield for clarification since I'm the author?
Yeah.
Yes, I will, Mr.
Yeah,
Chairman.
no, I think as long as they could continue to amend under their existing authorities on truth in billing and all, as long as they don't get into rate regulation, which I think we have general agreement we don't want them to do. So they could still, they've got general authorities they can use. We just said here we're not touching what they've already done in terms of, we want them to continue to have that authority. We just don't want it to spill over into where they do post facto rate regulation, if you will.
Reclaiming my time, I'd like to yield some time to Ms. Eshu.
Well, the last time I checked, it's only Congress that can write a statute. Is that, counsel, is that right or is it wrong?
That is.
I mean, is it right or is it wrong?
That is accurate.
All right. So this business of going left and turning right and going north and then go southeast and southwest and you can and you can't and we're going to pick and we're going to choose. You know what? We're skating on very thin ice in a markup to consider something that is applies to some things. We're not so sure about other things based on laws that are old, and what is present has really not been taken into consideration and vetted. So this is really getting messy. And to Mr. Barton, who is my cherished friend and partner on this committee, I don't care if it's one sentence or one page or 100 pages. It says what it says, and it falls short. It's not as simple as, I wish it were simpler. I tried to make it simple. I'll yield back to the gentlewoman. I think she makes excellent points.
I think, Ms. Eshu, and I'd like to note that the critical consumer protections embodied by the FCC's transparency rules are not included. Isn't the purpose of those rules to protect consumers and make sure they have sufficient information when purchasing broadband internet services? Madam Counsel?
I don't believe that those rules are affected or impacted by the amendment before us.
You don't believe that?
Because they are not related to the regulation of the rates charged, which is what's addressed in this amendment.
But when they purchase their broadband internet services, the rates are baked in, aren't they?
The transparency provisions are separate from this amendment. They are not affected by the way that the language.
And I think that really proves the point that my colleague, Ms. Eshu, and so many others have stated. If we're going to be legislating, creating statute in the 21st century, I think that we need to take the time to do the work that's required so that we're dealing with a comprehensive matter, this matter in a comprehensive manner. Mr. Chairman, I yield back.
Lady's time has expired. Chair would recognize the gentleman from Pennsylvania, Dr. Murphy.
I'd like to yield some time to Mr. Walden.
I thank the gentleman. I just have to clarify this. We believe in all the consumer protections my colleague from New York just talked about. That's why specifically in the legislation, we say, you still have all that authority over there on consumer billing, all those things. This is what's bizarre here. I'm having trouble following because we specifically in the legislation to address the issue that the gentlelady raised from New York say none of this applies. FCC, you still have your truth in billing. You still have all the consumer protection you've always had. This doesn't address, this just says on rate making only. And by the way, if we want to talk about ages of statutes, the FCC is going back to the 1800s when they regulated railroads and all to regulate the internet. I mean, it was, and you've got a 1934 Communications Act. So the age isn't the issue here. It's trying to make sure that consumers have all the protections. We do that in this bill. We don't mess with that. A simple reading of it will say that. That's why we do exceptions. And we put it in here to make it doubly certain. We wouldn't even have to have this in here to leave the same authority the FCC has. We specifically said, though, nothing in there takes away that authority. Second, what we are concerned about is a runaway FCC that will engage in rate regulation in reverse. They'll wait until a company has proposed something and has it out in the marketplace, and then they'll come back and second guess what was offered to consumers. That's why I point out what T-Mobile is doing. T-Mobile has a product, they put it out to consumers. Guess what? There's been big uptake by consumers, apparently. I mean, we saw, what, 34 petabytes of data, maybe $100 million in savings to consumers. That seems like a good thing. It's pro-consumer. This is a pro-consumer bill. This is a bill that says let's continue the vibrant marketplace we've had under the internet economy to allow people to innovate and not have a regulator for the first time come back and be able to say, sorry, you got it wrong. Here's the penalty. Stop what you're doing. These plans that are out there just starting to emerge in America are being used by others in other countries today. This is, the consumers will react. They'll react a lot faster than an FCC or a Congress. We're just saying, here's what rate means. It means the amount charged by a provider of broadband internet access service for the delivery of broadband internet traffic. And, regulate, it's pretty simple. The term regulation or regulate means with respect to a rate, the use by the Commission of Rulemaking and Enforcement Authority to establish, declare, or review the reasonableness of such rate. We define all this. It's a pretty simple bill, but it has big impact for consumers in a positive way and for innovation technology.
Would the gentleman yield?
I'd be happy to yield to my friend from New Jersey.
I couldn't disagree more. I'm very concerned that this bill is going to undermine the FCC's ability to protect consumers. And going back to what Mr. Barton said before, he says this is a very simple bill, but it's deceptively simple because it says only that the FCC may not regulate rates, but as many experts have pointed out, and I think the debate here shows that the term rate regulation could mean anything. And, the Republicans claim that they intend the bill to be narrow. We've heard over and over again, though, that from our side that this could swallow vast sections of the Communications Act.
Reclaiming my time.
I just, this idea that you're going to protect the consumer,
reclaiming my time,
I do not think is true. Yes.
Well, reclaiming my time, we've been very careful to make sure that consumers are not only protected, but they continue to have a vibrant marketplace where providers can innovate and offer them new choices. That's what's grown the internet to begin with. That's what we embrace. It is this FCC, who, by the way, initially did not want to go down the full Title II regulatory common carrier path until they were forced to by the White House. That's what we're trying to avoid here is full rate regulation or post facto rate regulation, the worst form of regulation. And that's what you're going to get. That's what you're going to get from this FCC or the next one is second guessing on rates. They're going to get involved in this, and you're going to regret the day that we did not pass this if we don't get it through here. So, Mr. Chairman, I yield back. I think we've made our case. The only final point I would make before yielding is for my colleagues on the other side of the aisle, I would think you would actually want to support this amendment since it improves the bill and addresses at least three of the issues Ms. Matsui raised, and then whatever you want to do on the final passage. I yield back.
Gentleman from Pennsylvania yields back his time. Other members wishing to speak on the amendment? Seeing none, the vote occurs on the Walden amendment. A roll call has been asked. Clerk will call the roll.
Mr. Barton. Mr. Barton votes aye. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Walden. Mr. Walden votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Blackburn. Mr. Scalise. Mr. Latta. Mr. Latta votes aye. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper votes aye. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Pompeo votes aye. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilirakis. Mr. Bilirakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Collins votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes no. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes no. Mr. Engel. Mr. Green. Mr. Green votes no. Ms. DeGette. Ms. Capps. Ms. Capps votes no. Mr. Doyle. Mr. Doyle votes no. Ms. Schakowsky. Ms. Schakowsky votes no. Mr. Butterfield. Mr. Butterfield votes no. Ms. Matsui. Ms. Matsui votes no. Ms. Castor. Ms. Castor votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. McNerney votes no. Mr. Welch. Mr. Welch votes no. Mr. Lujan. Mr. Lujan votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Ms. Clark. Ms. Clark votes no. Mr. Loebsack. Mr. Loebsack votes no. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas. Mr. Cardenas votes no. Chairman Upton.
Votes aye.
Chairman Upton votes aye.
Other members wishing to cast a vote? How's Mr. Engel voted?
Mr. Engel votes no.
Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 28 ayes, 21 noes.
28 ayes, 21 noes. The amendment is agreed to. Are there further amendments to the bill? Gentlelady from California, Ms. Eshoo.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the title.
I think it's Forbear 01.
Amendment to H.R. 2666, offered by Ms. Eshoo.
And the amendment will be considered as read. The staff will distribute the amendment, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I think the members of the full committee on both sides of the aisle are now familiar with this amendment. I offered it at the subcommittee, and what the amendment does very simply is to place or to codify what the FCC adopted, and that is no rate regulation and the forbearance as put forward by the Commission in Sections 203, 204, and 205, and to the extent Sections 201 and 202 could be read to allow the Commission to implement ex-ante rate regulation, they also forbore from those provisions too. So long story short, what this amendment expresses very simply is that we do not support the FCC setting the monthly recurring rate that consumers would pay for broadband internet access service. And this is a position that I think has been consistent with what the expressions of the chairman of the subcommittee have expressed, members on both sides of the aisle. I think it's very, very clear, and I offer this amendment, and I would ask not only the full consideration, but the support of members for this, because as I said a moment ago, it simply codifies the forbearance used in the FCC's order and ensures it cannot be reversed by a future commission. Period. Amen. I yield back.
Is there discussion of the gentlelady from California's amendment? The gentleman from Oregon seeks recognition.
Yeah, thank you, Mr. Chairman. I'm going to oppose the amendment, but I want to ask the council a question as we review this amendment. And my question is this: Council, would this amendment prohibit the FCC from any kind of post facto, in what I'll describe as post facto rate making, by going back after the fact and penalizing somebody for the rate that they charged?
No, sir. The FCC's existing forbearance leaves in place their enforcement authority.
All right. With that, I think this gets to the whole underlying issue I have with, in part, with this amendment, is that we don't want them rate regulating. I agree with my colleagues on that. We don't want them rate regulating after the fact either. And so that, among other issues of this amendment, lead me to oppose it, and I'd encourage my colleagues to do likewise, and I yield back.
I was just going to ask the gentleman to yield.
Does the gentleman want to yield to the gentlelady from California?
I certainly can, sure, of course.
Well, thank you very much. Let me just ask this. In the, to the extent that sections 201 and 202 could be read to allow the commission to implement these ex ante, if I'm pronouncing it correctly, rate regulation, the commission forbore from those provisions as well. So given what Mr. Walden just asked in your response, can you respond to 201 and 202 and the forbearance from those as well?
Section 10A of the Communications Act requires a test for forbearance that requires that the FCC be able to certify that forbearing from that provision will not affect their ability to ensure something is just and reasonable. It's circular reasoning to say that they can forbear from the test for just and reasonable rates under a test that requires you to determine that you have the ability to ensure justness and reasonableness.
So you're saying there's another test that the FCC could have put into place but didn't?
There's a
And that
test the
forbearance
FCC
is
itself
not
must apply.
What is forbearance?
The FCC, under Section 10A of the Communications Act, has a test for forbearance, which has a three-part test. The test requires that the FCC be able to show that forbearing from the rule is in the public interest. It has to show that forbearing from the rule is not necessary for the protection of consumers, and it has to show that enforcement of such regulation or provision is not necessary to ensure the charges, practices, classifications, or regulations by, for, or in connection with that telecommunications.
But what does that, are you saying that you don't, what's the implication here? That the forbearance that the FCC adopted is not solid enough? It's not believable? It's not sound? It doesn't, I don't understand what's being called into question.
Well, what's being called into question is whether or not Sections 201 and 202 can be forborne from by the FCC under its own motion.
So you think they went too far to, and went too far out of their way to not to regulate rates? Is that what you're implying?
No, my legal opinion is that they've exceeded their authority in making some of the guarantees.
Oh, God. Isn't that something? Thank you.
Does the gentleman yield back?
Yes.
Okay. Gentleman's time has expired. Is there other discussion of the issue amendment? The ranking member from New Jersey is recognized for 5 minutes.
Thank you, Mr. Chairman. I wanted to actually read for the record a letter from FCC Chairman Whaler, who wrote to me yesterday regarding the bill. And I think obviously the concern he has is the suggestion that somehow the approach in this legislation is consistent with previous comments he made. And I think after reading the letter, you can see that actually it's the issue amendment that is consistent with what Chairman Wheeler has previously testified to. So if I could just read this, it's not very long, and I think it's easier to just read it so everyone understands what what the Chairman Wheeler is saying. It says, Dear Congressman Pallone, I understand that the House Energy and Commerce Committee is about to mark up H.R. 266. There have been suggestions that the approach in this legislation is consistent with comments I made before the Senate Appropriations Committee last year. I want to state respectfully that it is not. In the open Internet order, the Commission expressly issued the future use of prescriptive industry-wide rate regulation. That is the law of the land. We achieve that goal by forbearing from the elements of the Communications Act that require prescriptive industry-wide rate regulations, sections 203, 204, and 205. To the extent sections 201 and 202 could be read to allow the Commission to implement ex ante rate regulation, we forbore from those provisions too. And this is the light touch regulatory framework that worked for mobile voice. The same approach will work for broadband. This broad forbearance in the open internet order was the basis of my comments to the Senate Appropriations Committee. Senator Boozman asked if I objected to Congress prohibiting the Commission from the rate regulation. I responded that if Congress wanted to ensure that a future Commission would be unable to unforbear, I would have no difficulty with it. What I said then remains true today. If Congress in its wisdom decides to make doubly sure that the forbearance in the open internet order is the law of the land, that is Congress's prerogative. But this bill does more than that. It would introduce significant uncertainty into the Commission's ability to enforce the three bright line rules that bar blocking, throttling, and paid prioritization rules, as well as our general conduct rule that would be applied to issues such as data caps and zero rating. It would also cast doubt on the ability of the Commission to ensure that broadband providers receiving universal service subsidies do not overcharge their consumers. Finally, it would hamstring aspects of the Commission's merger review process. I'm committed to ensuring that forbearance today is forbearance tomorrow, but I write to make plain that this bill is not consistent with the views that I expressed last year. And I think, in fact, the issue amendment is consistent with what Chairman Wheeler has testified to. I'd ask unanimous consent that the letter from Chairman Wheeler be entered into the record.
Without objection.
And obviously support the issue amendment for these reasons.
Gentleman yield back. Chair would recognize the gentleman from Illinois, Mr. Kinzinger.
Thank you, Mr. Chairman. I saw that letter, and actually it's kind of confusing. I'm not really sure why the Chairman Wheeler, sees the need to clarify his statements before the Senate appropriations to us, when his statements in this room were very clear. Would the clerk please pull up the excerpt from our March 15th, 2015 hearing? It was 1 year ago today that I had this interaction with Chairman Wheeler. I asked him whether this language would be consistent with the FCC's approach to prohibiting rate regulation. Would the clerk please read Section 2 of H.R. 20?
Parliamentary inquiry, Mr. Chairman.
As introduced.
Gentleman will state his parliamentary inquiry.
Well, again, you know, when we introduce these things, I think that the gentleman has to make a unanimous consent request.
He asked, I think.
I didn't hear that.
Yeah, he did.
Okay.
He did.
As long as that's
and we
the case.
approved your UC to put in your letter. Clerk will proceed, or the gentleman's time has started. Again.
Section 2, regulation of broadband rates prohibited. Notwithstanding any other provision of law, the Federal Communications Commission may not regulate rates charged for broadband internet access service as defined in the rules adopted in the report and order on remand declaratory reading and order that was adopted by the Commission February 26, 2015.
I guess we have a video queued up if we want to play that. It's me, so. That said, notwithstanding any provision of law, the Federal Communication Commission may not regulate the rates charged for broadband internet access service. That would be consistent with that view.
That is what we are trying to accomplish.
Okay. Commissioner Pai, we've heard Chairman Wheeler assert that his... All right. Mr. Chairman, it's the same text as Chairman Wheeler confirmed to us was consistent with his approach. I'm not sure what purpose this letter is except to serve in this markup, but Chairman Wheeler's testimony that our bill is consistent with his approach is very clear, and I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Gentlelady from Florida.
Thank you, Mr. Chairman. I yield my time to Ranking Member Pallone.
Mr. Chairman, I just would like to reiterate the relevant portion of that video that Mr. Kinzinger says. So if legislation that said, notwithstanding any provision of the law, the Federal Communications Commission may not regulate the rates charged for broadband internet access service, that would be consistent with that view. And that Mr. Wheeler, or Chairman Wheeler says, that is what we're trying to accomplish. So I think it's clear that Chairman Wheeler never said that he would support the language in H.R. 266. In fact, he specifically said that is what the FCC is doing without legislation. On the other hand, when he was testifying in the Senate last year, he was clear about what legislation he would support, and that is reflected, as I said, in the SU amendment. So I would urge anyone wishing to codify Mr. Chairman Wheeler's position to support the SU amendment. That clearly is consistent with his views. And I yield back.
Gentlelady yields back. Other members wishing to speak on the amendment? Seeing none, the vote occurs on the amendment offered by the gentlelady from California. Roll call is requested. Clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. No. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. No. Mr. Bouchon votes no. Mr. Flores. No. Mr. Flores votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. No. Mr. Mullen votes no. Mr. Hudson. No. Mr. Hudson votes no. Mr. Collins. No. Mr. Collins votes no. Mr. Kramer. No. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshu. Ms. Eshu votes aye. Mr. Engel. Mr. Green. Mr. Green votes no. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Mr. Butterfield. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton votes no.
Other members wishing to vote? Mr. Engel. Votes aye.
Mr. Engel votes aye.
Mr. Green?
Mr. Green is recorded no.
Done.
Mr. Green is off aye, on, off no, on aye.
Other members wishing to cast a vote? Seeing none, the vote, the clerk will report the tally. All right, guys.
Mr. Chairman, on that vote, there were 27 ayes, 20 noes.
20. Could the clerk report the, how many ayes?
27 ayes.
No. I think that's. I think it's. I think you're.
20 ayes, 27 noes.
There we go.
20 ayes, 27 noes. Mr. Green and Mr. Engel were a little confusing. The amendment is not agreed to, 20 to 27. Are there further amendments to the bill?
Mr. Chairman,
Gentlelady from California.
I have an amendment at the desk.
As amendment at the desk, clerk will read the title of the amendment.
Amendment to H.R. 2666, offered by Ms. Matsui.
The amendment will be considered as read. The staff will distribute the amendment, and the gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. Access to the free and open internet is an issue of economic competitiveness for every American, and that is why I supported the FCC's action last year to put strong net neutrality rules on the books. In the net neutrality order, the FCC made very clear that the agency has no intention of regulating consumer broadband rates. I don't believe the FCC should do so, and neither does the FCC chairman or President Obama. So while I agree with my Republican colleagues who have stated they don't want the FCC to set consumer broadband prices, I remain concerned that as written, H.R. 2666 goes far beyond what we all agree on and threatens the FCC's important duty to protect consumers. My amendment highlights some of the most glaring examples. My amendment ensures the FCC can fully enforce all of the net neutrality rules. We need the FCC to be flexible so that the internet remains a vibrant platform for innovation and free speech. It also preserves other FCC functions we all agree on, like universal service support for infrastructure deployment and connecting low-income consumers and schools and libraries. My amendment allows the FCC to go after fraud, like cramming on consumers' monthly phone bills. It also preserves the FCC's authorities when reviewing mergers between major corporations. I do appreciate that my Republican colleagues attempted to address some of the issues that I highlighted in my amendment. We agree that the FCC should be able to address billing scams and ensure every American has access to broadband. I'm especially pleased to see the Republican amendments speaks to my concern about fast and slow lanes on the internet by preserving a ban on paid prioritization. But my amendment would go further. It would ensure that all of the net neutrality rules, not just the ban on paid prioritization, are protected. And my amendment allows the FCC to be forward-looking and address discriminatory practices that could be future barriers to access. So while I appreciate these steps, I remain concerned about the potential unintended consequences of this bill, even as revised by today's Republican amendment. The future of the internet is so central to our economy and society, and we need to get it right. I urge all my colleagues to support my amendment to show they stand with consumers and innovators who need a strong FCC. I yield back.
Gentlelady yields back. Other members wishing to speak? Gentleman from Oregon is recognized.
Thank you, Mr. Chairman. I'll make this very brief. First of all, I appreciate working with the gentlelady. We found common ground on 3 of the 5 issues. Obviously, we couldn't find it on all of them, but I do want to set the record straight that there is nothing in what we're doing on the Republican side that prevents the enforcement of going after fraudulent activity, going after breach of contract, going after slamming and cramming. All of that continues under existing law. All that continues under existing law. It does not have to be restated. With that, I know we're on a time crunch, Mr. Chairman. I respect that, and I'd urge my colleagues to oppose Ms. Matsui's amendment.
Gentleman yields back. Chair would recognize gentleman from New Jersey.
Thank you, Mr. Chairman. I'll be brief as well. I support Congresswoman Matsui's amendment, even though the Republicans offered an 11th hour amendment that was intended to address our concerns. As we've already discussed, the Republican amendment doesn't go far enough. The Matsui amendment provides assurance that we will preserve authority of the FCC to act in the public interest on the issues that Democrats believe are essential, which includes consumer protection, discrimination, and unfair business practices, universal service, and merger reviews. So I urge members to support Ms. Matsui's amendment. I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seen none. The vote occurs on the amendment offered by on the gentlelady from California. Roll call is requested. Clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. No. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilrakis. Mr. Bilrakis votes no. Mr. Johnson. No. Mr. Johnson votes no. Mr. Long.
No.
Mr. Long votes no. Ms. Zelmers. Mr. Bouchon. No. Mr. Bouchon votes no. Mr. Flores. No. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. No. Mr. Mullen votes no. Mr. Hudson. No. Mr. Hudson votes no. Mr. Collins. No. Mr. Collins votes no. Mr. Kramer. No. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Welch votes aye. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Chairman Upton.
Votes no.
Chairman
Other
Upton
members
votes no.
wishing to cast a vote, Ms. Kathy McMorris Rogers.
Mrs. McMorris Rogers votes no.
Other members wishing to cast a vote? Seeing none, the clerk will report the, yep, Mr. Engel. How's Mr. Engel recorded? Aye.
Mr. Engel votes aye.
Other members wishing to record a vote? Seeing none, the clerk will report the tally on the amendment.
Mr. Chairman, on that vote, there were 20 ayes, 29 noes.
20 ayes, 29 nays. The amendment is not agreed to. Are there further amendments to the bill? Seeing none, the question now occurs on favorably reporting H.R. 2666 as amended to the House. All those in favor will say aye. Roll call request is made. The clerk will call the roll.
Mr. Barton. Mr. Barton votes aye. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Walden. Mr. Walden votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes aye. Mr. Latta. Mr. Latta votes aye. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes aye. Mr. Harper. Mr. Harper votes aye. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Pompeo votes aye. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilrakis. Mr. Bilrakis votes aye. Mr. Johnson. Mr. Johnson votes aye. Mr. Long. Mr. Long votes aye. Ms. Elmers. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Collins votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes no. Mr. Rush. Ms. Eshu. Ms. Eshu votes no. Mr. Engel. Mr. Engel votes no. Mr. Green. Mr. Green votes no. Ms. DeGette. Ms. Capps. Ms. Capps votes no. Mr. Doyle. Mr. Doyle votes no. Ms. Schakowsky. Mr. Butterfield. Mr. Butterfield votes no. Ms. Matsui. Ms. Matsui votes no. Ms. Castor. Ms. Castor votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. McNerney votes no. Mr. Welch. Mr. Welch votes no. Mr. Lujan. Mr. Lujan votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Ms. Clark. Ms. Clark votes no. Mr. Loebsack. Mr. Loebsack votes no. Mr. Schrader. Mr. Schrader votes no. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas. Mr. Chairman Upton.
Votes aye.
Chairman Upton votes aye.
Other members wishing to cast a vote? Seeing none, clerk will report the tally.
Mr. Chairman, on that vote, there were 29 ayes, 19 noes.
29 ayes, 19 noes. The bill as amended is passed and favorably reported. Chair will now call up H.R. 4725 and ask the clerk to report.
H.R. 4725, to reduce the federal deficit through reforms in spending under Medicaid, CHIP, and the Prevention and Public Health Fund.
And without objection, without objection, the first reading of the bill is dispensed with. The bill will be open for amendment at any point. Are there any bipartisan amendments to the bill? Seeing none, are there any amendments to the bill?
Chairman, I have an
Gentleman
amendment.
from Texas, Mr. Green, has an amendment to the bill. The clerk will report the title of the amendment. Which amendment?
Amendment number 2.
Amendment number 2. DO2.
Amendment to H.R. 4725, offered by Mr. Gene Green of Texas.
The amendment will be considered as read. The staff will distribute the amendment, and the gentleman from Texas will be recognized for 5 minutes.
I'd like to offer an amendment and plan to withdraw it. We should not be attempting to appease the most conservative members of the House by gutting programs that will help low-income families and children. Quite simply, that's what H.R. 4725 does. The amendment I'm offering strikes the misguided, unsound provision of H.R. 4725 that eliminates the enhanced Medicaid FMAP for inmates and replaces it with common sense provision to allow states that either not expanded or only recently expanded Medicaid to receive 3 full years of 100% federal match for Medicaid expansion. Prisoners receive their coverage from their prison health system, not Medicaid. However, when a prisoner must be admitted for a serious inpatient care for longer than 24 hours, a state can claim federal Medicaid matching assistance at the rate applicable for that population in any given state. Now, that means if your state expanded Medicaid, a lot of these folks are eligible for enhanced Medicaid expansion matching rate because prisoners generally fit the low-income adult category. The legislation before us would punish these states that expanded Medicaid and reduce that matching rate back to the standard rate with no notice or at a time when states are 3/4 of the way through their budget cycles. The savings from this provision come literally from leaving a hole in state budgets. I believe this is wrong tack all around. I believe we should be doing everything to expand Medicaid and help states not simply shift more cost onto the states as this legislation proposes to do. I remind my colleagues that my proposal incentivizes states to expand Medicaid by allowing them to receive the full 100% match for the first 3 years they chose to expand as common sense policy. In the 19 states that have yet to expand Medicaid, more than 4 million people could gain coverage. States could realize major savings in other parts of their budgets, and billions of dollars in uncompensated care costs would be avoided. States have a modest portion of the expansion to pay but reap the benefits of billions in savings to their economies. One study estimated that each new state dollar invested in Medicaid expansion would draw down $13.41 in additional federal dollars. Expansion states are reporting positive budget impacts, and nationally, 78% of the new Medicaid enrollees who have obtained care say they would not have been able to afford or access this care prior to gaining Medicaid coverage. Low-income adults in these states have more access to health care services, fewer problems paying their medical bills, and hospitals in expansion states are admitting fewer uninsured patients. Rather than being expensive for states, and expansion makes budgetary sense for states. A recent analysis of Virginia and other expansion states shows Medicaid expansion can actually save states money. According to a report by the National Public Radio, the decision by Texas to reject expansion of Medicaid would prevent the state from receiving an estimated $1 billion in federal funds over a decade. At the same time, its hospitals are eating $5.5 billion in costs for treating uninsured people, the majority of whom wouldn't be uninsured if the state took up the Medicaid expansion. These uncompensated costs, in turn, are being covered by taxes and insurance premiums paid by the state's businesses and residents. States that took up Medicaid expansion as a rule have seen a marked decline in their uninsured rates and the amount of their costs their hospital incurred in caring for people without insurance. Medicaid expansion is just common sense. Let's help those 19 remaining states to do the right thing, Mr. Chairman. This amendment, I'd introduce it and withdraw it, but I want to make the point that the expansion of Medicaid for states is such a big issue. Even in Texas, we would see we're losing $100 billion of federal funding and reimbursement. And I'll withdraw this amendment.
Well, before you withdraw, the gentleman from New Jersey would like to speak on it. So,
glad to yield my time.
You want more time? You want your own?
No, I think I need my own time.
Okay, I yield back my time, Mr. Chairman.
Gentleman yields back. Other members wishing to speak on the amendment? Gentleman from New Jersey is recognized for 5 minutes.
I just want to say I strongly support the amendment because it incentivizes all states to expand Medicaid, and the numbers don't lie. Expansion is a good deal for state economies and the federal government. Expansion states are also reporting positive budget impacts. These fiscal impacts are substantial, with one study estimating savings in revenue of $1.8 billion by the end of 2015 across the 8 expansion states it examined. Medicaid is a jobs creator. Independent analysis undertaken in the state of Kentucky's request found that for Kentucky alone, Medicaid expansion created 12,000 jobs in the first year, and estimates are that the state will have created 40,000 jobs and created a positive $30 billion impact on the state's economy through 2021. While benefiting from slower spending growth, expansion states are making substantial progress in reducing the ranks of the uninsured and lowering costs of uncompensated care. If all states expanded Medicaid, savings on reduced uncompensated care alone would offset between 13 and 25% of that additional state spending. And Medicaid expansion is life-changing for beneficiaries. The ACA coverage provisions are reducing uninsurance rates nationwide, with the biggest gains occurring in states that have expanded Medicaid. Multiple studies show that poor adults in states that have expanded Medicaid as part of health reform have greater access to health care services and fewer problems paying their medical bills, and hospitals there are admitting fewer uninsured patients. Not expanding Medicaid has a real and measurable impact on individuals every single day. In fact, if all non-expansion states had a rate of children's coverage comparable to states that have expanded, it's estimated that at least 1,027,000 more children would have health coverage. So I think we have to do everything, Mr. Chairman, we can to incentivize states that haven't expanded yet to do the right thing for their citizens. I know the gentleman's going to withdraw this amendment, but I think it's a point well made about the value of incentivizing Medicaid expansion. I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seeing none, does the gentleman from Texas withdraw his amendment? Mr. Green, ask unanimous consent to withdraw his amendment. The amendment is withdrawn. Chair would recognize the gentleman from West Virginia. Strike the last word.
Strike the last word, Mr. Speaker, Mr. Chairman. I would like to rise and raise a point of colloquy with you, Mr. Chairman, if that would be appropriate.
Yeah, go ahead.
Colloquy. Mr. Chairman, the small rural hospitals all across America have really become alarmed over CMS's treatment of the provider tax that we're going to be discussing in this legislation. Just in my own state of West Virginia, a third of all our hospitals are classified as critical access hospitals. And the impact that CMS has done retroactively is going to have a crushing blow, not only on states like West Virginia, but all critical access hospitals across America with this. It's going to cost them millions of dollars, and it's done retroactively. You have to understand, Mr. Chairman, these same hospitals applied to CMS and were given instructions that they would be able to use the provider taxes as a means of reimbursement. And now CMS has absolutely reversed themselves and now saying they can't, but compounding it is that they want to do it retroactively. So these small hospitals that are struggling, just absolutely on their heels, are being told that they're going to be penalized millions of dollars back as far as 2009. I think we have to be careful about that. And so Mr. Chairman, if they're struggling now the way things are, and then to be faced with retroactive penalties, I think this is punitive. And it doesn't show how we're working as a Congress and an administration to address some of the hardships that our small rural hospitals are trying to do. They're taking care of our poor and underserved. We've got to take care of these hospitals. So, Mr. Chairman, I'm asking you as part of this legislation and as we go forward with it, do I have some assurance that we can work together to correct this unfair targeting? But more specifically, will you work with us to oppose a retroactive penalty?
Yeah, I'd just like to assure the gentleman on the record that this provision would not make any of this retroactive. And that I know that in the case of West Virginia, I want to say that it's in the courts or it's being appealed. This will have no impact on those years from 2009 forward. So it does not do that. I wanted to give the gentleman that assurance and appreciate his thoughts on it.
And can you work with going into the future that we can still address this through this committee?
Yeah, look forward to working with the gentleman.
Thank you very much.
Thank you. Gentleman's time has expired. Chair would recognize the gentlelady from California. Ms. Capps, I'm told, is for an amendment, or no? Clerk, they asked me to do. Yeah. Yes, gentlelady from California has an amendment at the desk. The clerk will read the title of the amendment.
Amendment to H.R. 4725.
Number
offered by Ms. Capps.
And with the amendment will be considered as read. The staff will distribute the amendment, and the gentlelady from California is recognized for 5 minutes in support of her amendment.
Mr. Chairman, I do have an amendment at the desk. Mr. Chairman, the Medicaid program is an important state-federal partnership to provide needed health care services to some of the most vulnerable populations, including the working poor, low-income seniors, persons with disabilities, and children. I really appreciate the comments of my colleague from West Virginia, Mr. McKinley, to this point. It is only effective if this partnership is strong. Unfortunately, the bill before us would seriously damage that relationship. Perhaps the most egregious way is by reducing the ability of states to finance their share of the program by using provider taxes. The provision in this bill to cut provider taxes is once again an attempt by the majority to slash funding to Medicaid without much concern for the impact that would have on individuals and communities. But if we further restrict the use of provider taxes, taxes that the medical community actually wants to pay, we will take our state's legs out from under them. This would effectively cut services to entire communities, not just Medicaid beneficiaries, and make access to care that much more difficult. Provider taxes enable all of our home states to maintain a stable, functioning Medicaid program by helping to pay for the non-federal share of Medicaid programming. It is a highly regulated system to protect from abuse with the buy-in and support of the medical community who recognize the contribution to this, their contribution to this program. Blocking or reducing the ability of states to use provider taxes is bad for the program that needs these fees to ensure full financing of the program. It is dangerous for the patients who may be blocked from care if state budgets are constrained, and it is detrimental to the broader healthcare system and communities across the country who could see their community hospitals close due to being overwhelmed by and undercompensated care. That means that doors would be closed for everyone that they might need to serve, not just those in the Medicaid program. Moreover, blocking or reducing the ability of states to use provider taxes is an inefficient way to reduce spending. In fact, $2 needs to be squeezed out of the program for the federal government to see an even $1 reduction in spending. And the money that goes to states isn't a handout. It is based on actual need and the actual care received by patients. These costs won't disappear if this bill passes. It simply shifts the cost to the states. And again, the costs don't disappear and the need for the care doesn't disappear. That's why CBO expects that if provider taxes are reduced or eliminated, the states would not be able to replace all of the lost revenue and would have to cut their Medicaid programs to offset the loss of funds. That is bad for patients, the healthcare system, local communities, and state budgets. And that is why my amendment simply strikes Section 4 of the bill before us, preserving the ability of states to continue assessing their provider taxes. This is particularly important as the misguided provision in the bill would immediately affect half of the states, including many of the states represented by members on this committee, like California, Pennsylvania, North Carolina, Washington, and others. These states have already cut their budgets, already set their budgets, but this bill would undercut those efforts and send them into turmoil. Therefore, I ask you to join me in stopping this particularly direct blow to our communities. Support my amendment to support your state. It's a states' rights bill. Support my amendment to preserve the federal-state Medicaid partnership, and support this amendment so that we can protect access to health care services where they're needed most right in our communities. And I'm prepared to yield the remaining 1 minute, or I will yield back.
Gentlelady yields back. Gentleman from Pennsylvania, Mr. Pitts, recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I rise in opposition to this amendment. This funding mechanism has been called a gimmick by President Obama's Bipartisan Fiscal Commission, called a scam by the Vice President, called a bit of a charade by Senator Dick Durbin. My colleagues may be as surprised as I am that I find myself, for once, agreeing with sentiments previously expressed by the President, Vice President, and Senator Durbin, but the underlying policy is less aggressive than what President Obama previously called for. In fact, the bill would simply reset the provider tax hold harmless threshold at the level that it was in 2011 under President Obama. And I urge my colleagues to oppose the amendment. Yield back.
Gentleman yields back. Gentleman from New Jersey.
Thank you, Mr. Chairman. I urge support for the CAPS amendment. Today, 49 states and the District of Columbia use provider taxes in some form to help pay for the non-federal share of their Medicaid program. With health care costs continuing to grow and Medicaid taking up an ever larger share of state budgets, provider taxes enable states to maintain a stable, functioning Medicaid program. And this amendment hits nearly half of all states. Cuts in provider taxes do not increase efficiency or performance. They're simply a cost shift onto states. When states cut back on Medicaid, local governments and essential hospitals bear the brunt of the cost burden. The cost shift trail ultimately reduces the care available for Medicaid beneficiaries, which means vulnerable populations may be denied coverage and benefits at a time when they need them the most. The CBO estimates that barring or sharply restricting states from using provider taxes would produce federal savings because CBO expects that states would not be able to replace all the lost revenue and would cut their Medicaid programs to offset the loss of funds. So the impact on low-income people by denying states the ability to use this financing source is irrefutable. So I support the amendment to strike this section of the bill. I yield back, Mr. Chairman.
Gentleman yields back. Other members wishing to speak on the amendment? Seen. Gentleman from New York, recognized for 5 minutes.
Thank you, Mr. Chair. I move to strike the last word and speak in support of the CAPS amendment. This limiting measure, or the elimination of state use of provider assessments for Medicaid programs, I believe would result in damaging cuts for patients and undermine the Medicaid expansion. I know that in New York, we're one of the 26 states, I believe, that would be affected by this proposal. It certainly would impact our efforts to continue with some very significant stabilizing, functioning programs in Medicaid. And because of the impact on my home state of New York, I would urge my colleagues to support the CAPS amendment to remove the provider assessment section of the bill, which would directly affect given Medicaid beneficiaries. And with that, I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seen none. Question occurs on the amendment offered by the gentlelady from California.
Mr. Chairman, we'd ask
roll
for
call is
roll.
requested. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone.
Aye.
Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo.
Aye.
Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton votes no.
Other members wishing to vote? Mr. Engel.
Mr. Engel votes aye.
Dr. Bouchon, are you recorded? Ms. Brooks?
Mr. Bouchon votes aye.
Ms. Brooks?
Ms. Brooks votes aye.
Other members wishing to cast a vote? Seen none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 19 ayes and 28 noes.
19 ayes, 28 noes. The amendment is not agreed to. Should I recognize that for Ms. Castor has an amendment at the desk?
Yes, I have an amendment at the desk.
And the number, please. Clerk will report the title of the amendment. I think is it D07?
07.
D07. Clerk will report the title.
Amendment to H.R. 4725, offered by Ms. Castor of Florida.
The amendment will be considered as read, and the staff will distribute the amendments, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. Members, less than a year ago, Democrats and Republicans came together to pass the Medicare Access and Children's Health Insurance Reauthorization Act. This was the big SGR repeal, but it also set policy for the Children's Health Insurance Program, known as SCHIP, and a higher matching rate for states through 2019. This was terrific news. It was an important bipartisan effort. I believe it was probably almost unanimously supported by members in this committee. And it was terrific news because it meant that more children in America will get health coverage they need to succeed. It was also good news for the taxpayers, as research shows that investing in health coverage for children provides a strong long-term return because children grow up healthier, better educated, and more economically successful as adults. And despite all the acrimony over health policy over the past few years, whether it's up here in Congress or at the state level over Medicaid expansion, this was a great example of Democrats and Republicans coming together, feds and states coming together to take care of kids, to ensure that they can see a doctor. So I have to say, we were very taken aback that Republicans would propose to renege on the agreement in the legislation that was adopted last year, to the detriment of children across this country. This Republican bill, which really appeared out of the blue, probably at the insistence of the Tea Party members, that's what it appears, that's what folks are saying, but this Republican bill will pull the rug out from under children, families, and states who you made a commitment to just last year. You know, states have relied on this policy, on this new law, and made a commitment to expand and improve children's health benefits. This is no way to chart important policy relating to children's health policy, and it's no way to treat America's kids. This Republican bill will be especially disruptive as states are already 3/4 of their way through this fiscal year. Many have already considered their upcoming 2017 budgets. In the state of Florida, our legislative session ended last Friday. They have relied on the commitment that we made through MACRA and the CHIP reauthorization, and in doing so, they said we are going to improve health benefits for children in Florida, and other states are going through the same exercise. So my amendment says that this section of the bill related to the CHIP reauthorization cannot take effect unless and until HHS certifies that there's no impact to children currently covered by CHIP, and it cannot impact current state plans. If you oppose the amendment, you're supporting a significant ratcheting back on children's health insurance, and you are saying you are breaking the commitment you made last year as part of that very important MACRA bill. So I urge my Republican colleagues, especially those of you who supported the Children's Health Insurance reauthorization last year, not to turn your back on kids that need to get to the doctor's office. Support this amendment, vote yes on this amendment, and I'm happy to yield back my time. Thank you.
Gentlelady yields back. Chair to recognize gentleman from Kentucky, Mr. Guthrie.
Thank you, Mr. Chairman. I move to strike the last word. I oppose this amendment because it guts Section 5 of the underlying bill. That section would eliminate the 23 percentage point increase in the CHIP funding, matching the rate implemented in the Affordable Care Act. Section 5 of the underlying bill extends the life of the current CHIP program. Under the base policy in Section 5, according to CBO, in 2018, about 700,000 more children or pregnant moms will be enrolled in CHIP due to Section 5. And in 2019, 2.5 million more children or pregnant moms will be enrolled in CHIP than under current law. I further oppose this amendment because it would increase the federal deficit relative to the base bill. Nonpartisan economists warn us that federal health care programs are adding significant pressure to our federal budget and are the biggest drivers of our debt and deficits. We can help low-income kids while also protecting taxpayers. Growing debt and deficits threaten the very future of the many children CHIP aims to help. Congress has a responsibility to reduce deficits and growing our debt burden to protect our children and grandchildren. I yield back.
Gentleman yields back. Chair will recognize the ranking member of the full committee, Mr. Pallone.
Thank you, Mr. Chairman. I urge support for the Castor Amendment. Section 5 of this legislation would roll back the deal that we all made overwhelmingly in a bipartisan fashion when we enacted MACRA just last year. That legislation reaffirmed the so-called 23% bump, and the CHIP bump increased the federal share of the cost by 23% or percentage points across the board. The enhanced match rate for CHIP now ranges from 88% to 100%. States use this money to fund things like additional outreach and enrollment for uninsured kids, improve benefits, and they also strengthen the administrative capacity and quality metrics in their programs. It's troubling that this proposal is even in the mix when the same group of members here today voted just last year to extend CHIP with the bump. It seems my Republican colleagues are poised to take a vote that will pull the rug out from efforts to help uninsured kids in their own states by the end of the month, within 17 days. I'm not sure why low-income and uninsured kids are completely fine to put on the table in a budget debate. I simply can't understand how low-income kids can be the group Republicans are fine with harming. But that's what we have here today, and that's why the Castor Amendment is critical. If Republicans truly mean vulnerable children no harm, then I urge all of us on a bipartisan basis to support this amendment and keep the promise we made when we enacted MACRA just last year. I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Gentlelady from California.
Thank you, Mr. Chairman. I also want to strike the last word to speak on behalf of this amendment. Many of us have come to this Congress to work to this particular committee to work to extend health care access to those who need it the most. This bill before us does just the opposite by slashing funds to the Children's Health Insurance Program, SCHIP, or CHIP as we know it. It is unfortunate that the health of our nation's children is being jeopardized for a budget gimmick, especially when these funds were reaffirmed, as was mentioned, in the reauthorization of the program last year, funds that we as a committee have supported unanimously. Since its inception, CHIP, a bipartisan supported program, has been critical to the health care for our children. It has let parents rest easier. It has shown the nation what bipartisan support can do to make a real impact on each of our communities. As a longtime school nurse, I cannot impress upon my colleagues enough the importance of our children having a formal connection to the healthcare system, not just when they get sick and end up in the emergency room, but to keep them healthy, thriving, growing, and ready to learn. The CHIP program, SCHIP program, is key to the health and economic security of our families. It links over 8 million of our nation's children to care and to services. It has proven to be a cost-effective program that successfully provides affordable, accessible health insurance for children in our communities. In my state, it's called, Medicare is called Medi-Cal, or Medicaid is called Medi-Cal. These programs have cut the rate of children's insurance with, combined with SCHIP in California by half. So it's really effective. It's something that we must support and continue to support, and that's why this amendment is important that we adopt and add to our agenda today, and I yield back.
Gentlelady yields back. Other members wishing to speak? Seeing none, the vote occurs on the amendment offered by the lady from Florida. Roll call is requested. The clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Burgess. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton votes no.
Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 19 ayes, 27 noes.
19 ayes, 27 noes. The amendment is not agreed to. Are there further amendments to the bill? Gentlelady from Illinois, Ms. Schakowsky, has an amendment at the desk.
I have an amendment at the desk, Mr.
Clerk will report the title of the amendment. I believe it's
the number.
D01.
Number, D01.
Amendment to H.R. 4725, offered by Ms. Schakowsky of Illinois.
And the amendment will be considered as read. The staff will distribute the amendment, and the gentlelady is recognized for 5 minutes in support of her amendment.
Thank you, Mr. Chairman. I rise to offer an amendment that would protect the most vulnerable members of our society, children, the elderly, and the disabled, from being removed from Medicaid. This amendment ensures that no low-income child or otherwise vulnerable individual cycles on and off Medicaid coverage simply because their household gains income in any given month in the form of a lump sum, which frankly is not the same as so-called millionaire jackpot winners, as the Republicans claim. It can be something as selling a car that they have. The provision included in the underlying legislation is not targeted at millionaires or at lottery winners. We know this because we already have safeguards to prevent against the very circumstances this provision claims to fix. Today, under the ACA's streamlined approach to coverage, a lump sum payment is counted in Medicaid as income in the month in which it is received, and it is settled up at the end of the year. So a lump sum income that is taxable is included in an individual's annual income that is used to calculate their eligibility for a premium tax credit or redetermine their Medicaid eligibility. So we take care of that. Furthermore, the ACA implemented several additional checks for detecting which individuals have received higher incomes for a period of time. For example, CMS requires that enrollees notify the state Medicaid agency immediately if they have a change of circumstances that affects their eligibility for Medicaid coverage. And in reality, this provision would have the practical effect of kicking children off coverage who have received no winnings or payments at all. This is because Medicaid eligibility is calculated by household income, although the majority of actual Medicaid enrollees are children, the elderly, and disabled. And I know none of my colleagues came here to Congress to make sure that those vulnerable individuals lose their Medicaid. In fact, 1 of every 3 children in America is covered under Medicaid. So this means that if a parent of a Medicaid child were to receive lump sum income under the legislation, it would be the child that would lose the coverage. Nationwide, 33 million children are covered by Medicaid. In Illinois alone, 1.5 million children are on Medicaid, which is over 45% of children in Illinois. But this provision would not only harm children, it would also kick individuals' disabilities and the elderly off Medicaid if someone in their household receives a lump sum payment, even a modest one. Medicaid provides insurance to nearly 9 million non-elderly individuals with disabilities. In addition, 70% of nursing home residents rely on Medicaid. These individuals do not have the means to be cycled on and off Medicaid from one month to another. Moreover, it's unclear exactly how they would get health insurance coverage for a month or two at a time after being removed from Medicaid. Certainly none of us came to Congress to take away health insurance from children, the elderly, or the disabled. But unfortunately today, we are faced with a bill that would do just that. I urge my colleagues to support my amendment to ensure that the most vulnerable in our society are not left without the care that they need. And unless someone else wants the time, I yield back.
Gentlelady yields back. Other members wishing to speak on the amendment? Gentleman from Pennsylvania, Mr. Pitts.
Thank you, Mr. Chairman. I oppose this amendment. This amendment would gut the common sense provision that we require states to consider income from high dollar lottery winners when assessing Medicaid eligibility. Since its creation in 1965, Medicaid has always been a means-tested entitlement. A core standard for eligibility for the program is whether or not an applicant meets certain income eligibility thresholds. This policy will not take away coverage for the elderly or the disabled. The bill only impacts the calculation of modified adjusted gross income, which is not used to determine their eligibility. This policy will not take away coverage from low-income families who need it. Under the bill, lottery winnings of less than $60,000 would be exempted, but each $10,000 increment of winnings above that amount would be counted as income for an additional month. If a lottery winner under this bill is not eligible for Medicaid, they would still be allowed to purchase health insurance elsewhere, which proponents of the Affordable Care Act should support. Additionally, the threshold of $60,000 in the bill is incredibly generous, set at more than 200% of the federal poverty level for a family of 5. To give you a sense of this generous threshold, the U.S. Census Bureau reported in 2014 that the median household income in the country was $51,939. So, Mr. Chairman, the Schakowsky Amendment is a good example of why I think a lot of the American people are frustrated with Washington at a time when economists warn us that our federal budget's runaway spending path will soon lead to the return of trillion-dollar annual deficits and could threaten our economic stability. The Schakowsky Amendment lets the Secretary of HHS gut the requirement that lottery winnings be counted as income for purposes for determining Medicaid eligibility. For this reason, I urge my colleagues to oppose.
Would the gentleman yield for just a minute?
Yes.
Yeah.
Yes.
Thank you. I appreciate that. let me just say, it is not just about lottery winnings. It is about any kind of lump sum income, and it is all settled up at the end of the year. What we're trying to avoid is the cycling on and off for a month. And that really does become a problem, because then someone has to go back and re-register to be on Medicaid again, which could really harm the continuity for children. So I'm not at all against the idea that somebody, first of all, you know, the very few people who win big money in lotteries, but, you know, it can be the sale of property or something that would cause them to rise above that. And at the end of the year, then they would have to settle up both in eligibility and in income taxes. And so I just, it's the continuity that we want to make sure that particularly the children and people with disabilities and the elderly have, not to have to worry month to month about all the paperwork and all the just the confusion about getting on and off of Medicaid. I yield back. I thank the gentleman for yielding. I yield back to him.
Gentleman yields back. Time has expired. Other members wishing to speak? Seeing none, the vote occurs on the amendment offered by the gentlelady from Illinois. All those in favor will say aye. Roll call vote is requested. Clerk will call the roll.
Mr. Barton. Mr. Barton votes no. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Griffith. Mr. Griffith votes no. Mr. Bilrakis. Mr. Bilrakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton votes.
Other members wishing to vote? Mr. Harper.
Mr. Harper votes no.
Other members? Seeing none, the clerk will report the tally. Mr. Engel?
Mr. Engel votes aye.
Mr. Mullen? Oh, he's okay. All right. He's recorded. Clerk report the tally.
Mr. Chairman, on that vote, there were 20 ayes and 28 noes.
The amendment is not agreed to. Are there further amendments to the bill?
Mr. Chairman, I have an amendment at the desk.
Lady from California has an amendment at the desk. Clerk, report the title.
Amendment to H.R. 4725, offered by Ms. Matsui.
And with that, the amendment will be considered as read. The staff will distribute the amendment, and the gentlelady from California will be recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, this amendment would require the Secretary of Health and Human Services to certify before this bill can go into effect that nothing in the bill will result in a loss of funding to states for the provision of comprehensive mental health and substance abuse services. We are in a critical time for mental health funding, when 1 in 7 Americans is affected by mental illness, and we are facing an opioid epidemic. We have to step up and ensure that people have access to the services and supports that need to recover. Medicaid provides over 1/4 of both mental health and substance abuse spending in this country. If we truly want to save money and lives, we need to invest in these services so that people get the care that they need as early as possible. The Affordable Care Act is reducing uninsurance rates and increasing access to care and mental health care nationwide, but much less so in states that have not yet expanded Medicaid. Not expanding Medicaid has a real and measurable impact on individuals every single day, especially those with mental illnesses and substance abuse disorders. According to a 2013 report done by the National Alliance on Mental Illness, or NAMI, Medicaid is the most important source of financing for mental health services in America today, and expanding Medicaid will fill critical gaps in access to health and mental health care. My amendment would ensure that this bill could not cut funding for critical mental health and substance abuse funding, which I believe is an investment in our nation's health. I urge my colleagues to support this amendment. Thank you, and I yield back.
Gentlelady yields back. Other members wishing to speak on the amendment? Mr. Pitts is recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in opposition to the Matsui amendment. This prevention fund is truly a slush fund. Gives the executive branch extraordinary authority, but there's no guarantee on what they will spend it or how much they will spend. We have cited in the past some of these questionable grants they've made, things like pickleball from the prevention fund for the Cadott County, North Carolina, massage therapy, kickboxing, kayaking, Zumba, whatever that is, to the Waco, Texas, $235,000 grant. Free pet neutering for the city of Nashville, $7.5 million for free pet spaying and neutering. Urban gardening for the city of Boston, $1 million. New York for lobbying against a soda tax, or for a soda tax initiative, $3 million. On and on. This legislation will not result in the loss of funding to states for the provision of mental health and substance abuse services through the Substance Abuse or Mental Health Administration. You don't need a slush fund to prioritize mental health funding. And so the Congress ought to be the ones who appropriate, who provide this funding. It should not be a slush fund that gets $2 billion a year ad infinitum in perpetuity. And so we need to present solutions to prioritize spending rather than choosing to ignore the problem. And I urge my colleagues to vote no on this amendment. Yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Gentlelady from Illinois. I saw her hand first.
Thank you, Mr. Chairman. I move to strike the last word. Any suggestion that the Prevention and Public Health Fund is a slush fund for the Secretary of the Department of Health and Human Services is simply inaccurate. The Affordable Care Act granted explicit authority to Congress to allocate funding in the Prevention Fund, and since fiscal year 2014, Congress has used its authority to allocate the funds from the Prevention Fund. I just want to mention in Illinois. My home state of Illinois has received $92 million from the fund since its creation in 2010, and these funds have helped to create programs to, for example, prevent diabetes, assist with smoking cessation, and reduce childhood obesity. The same is true of the FY26 appropriation legislation. Therefore, the Secretary has no discretion to allocate any of the prevention fund. Not only does the Secretary not have any control in allocating the funding, HHS must maintain a publicly available website that details the funding allocations of the prevention fund, as well as funding opportunities and awards from programs funded with prevention dollars. Such transparency makes it possible for anyone to learn where prevention funds dollars are being used. And I think if the public takes the opportunity to look at that website, they will be very happy with what they see. Rather than supporting programs that waste money, as the slush fund allegation implies, the prevention fund is being used, as it is in Illinois, to fund life-saving public health programs that prevent and combat chronic conditions, as I said, such as diabetes, and prevention programs, obesity prevention programs, tobacco cessation programs. Rather than waste money, such investments in prevention can actually save us money as well as save us lives. As we know, chronic conditions such as diabetes, lung disease, and heart disease account for 7 out of 10 deaths in the United States and 86% of all healthcare spending in the United States. Reversing chronic disease trends in the United States by preventing the onset of chronic disease not only makes good financial sense, but it makes for good healthcare policy. And I urge my colleagues to reject the elimination of this very important prevention fund. And I yield back.
Mr. Chairman, would the lady yield?
Yes, I'd be happy to yield to the gentleman.
Mr. Chairman, thank the lady for yielding, but I wasn't going to speak on this, but I wanted to make sure my chair of the Health Subcommittee understands what Zumba is.
Zumba, it is.
No, well, Zumba, it's a dance, but it's also an exercise. And in our district, we have dozens of those groups, because I've actually been to some of them and seen the exercise work. So it's prevention. And in the community I represent, where diabetes is epidemic, our goal is to make sure those prevention funds work. And so if we can get them out dancing, whatever, country, western, whatever, it actually gets them moving around, and it will lower the diabetes rate. So this prevention fund is important, but I just wanted to make sure you know it may be a regional issue, but in our area, Zumba is very popular with a whole lot of my constituents. And thank you for yielding.
And I yield back.
Gentleman from Pennsylvania, Dr. Murphy, asked for time.
Yes, on the amendment, if I strike the last word. Look, we all know we've got to reform the mental health system. Full-page ad in today's Politico talks about it. We know we're tired of the moments of silence. We know this has to change. I've been meeting with just about everybody in this committee, and we know we're all committed to do this. I hope this committee takes up soon comprehensive mental health reform. Part of this is funding, and I appreciate what Ms. Matsui is trying to do. I know that she is passionate about this issue, as everybody else is here. That's what we ought to be addressing. And I pray we do this before we have one more killing, one more suicide, or anybody else gets harmed, but I know that won't happen, because it's happened several times just during this markup. So I would ask that that be the way we approach this, by comprehensive mental health reform. I know I've been with Mr. Pallone on this. He's passionate about it too. Everybody is here. Let's approach this the right way. I yield back.
Gentleman yields back. Other members wishing to speak on the amendment? Seeing none, the vote occurs on the amendment. Roll call is requested. Clerk will call the roll.
Mr. Barton. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Bilirakis. Mr. Bilirakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Loebsack. Mr. Loebsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton.
Other
votes-
members wishing to cast? Mr. Harper.
Mr. Harper votes no.
Other members? Seeing none, the clerk will report the tally. Oh, Mr. Engel. Nope, Mr. Barton. How's Mr. Barton? Mr. Barton's recorded as no. Other members? Seeing none, the clerk will report the tally.
Mr. Chairman, on that vote, there were 19 ayes, 26 noes.
19 ayes, 26 noes. The amendment is not agreed to. Are there other amendments to the bill?
I have an amendment, Mr. Chairman.
Mr. Green has an amendment. The clerk will report the title of the amendment.
Sir, what's the number?
Number 4.
Is it MD4 or D04?
MD4 04. The one on the Zika outbreak.
Amendment to H.R. 4725, offered by Mr. Green.
The amendment will be considered read. The staff will distribute the amendment. The gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. And my amendment will prevent the proposed cuts to the Prevention and Public Health Fund until Dr. Frieden from the CDC would certify that all U.S., state, local, and territorial health officials have the epidemiology and the laboratory capacity to track and respond to the Zika outbreak. That's what this fund is for. The Prevention and Public Health Fund is to track these type illnesses. And I strongly oppose the repeal of the Prevention and Public Health Fund because it's helping to improve public health across the country. One example of how the Prevention Fund is helping increase our investments in prevention and improving public health in every state is the Epidemiology Laboratory Capacity, the ELC program. Congress provided $40 million in fiscal year 2016 through the Prevention and Public Health Fund to improve states' ability to detect, diagnose, and contain disease outbreaks through the Epidemiology Laboratory Capacity Program. That equates to nearly 40% of the state's surveillance of funding. The epidemiology and lab capacity grants support state-of-the-art laboratories, state-of-the-art laboratories, trained epidemiologists who can investigate infections before they become widespread. The ELC grants enable states to rapidly detect and contain foodborne outbreaks like multi-state listeria outbreak last year, investments in epidemiology and laboratory capacity in Arizona and Kansas, Oklahoma and Texas allowed these states to investigate a listeria outbreak linked to dairy products and saving lives and healthcare costs. Not only is the epidemiology and laboratory capacity program vital to the building states' laboratory and workforce capacity to investigate and respond to the Zika or other infectious disease outbreaks, several states currently are using this fund to support their efforts to prepare and respond to the Zika outbreak. As the Centers for Disease Control and Prevention, along with state and territorial public health officials, work to better understand and respond to Zika virus and its health impacts, particularly on pregnant women, infants, and we cannot afford to reduce our investment in these core public health functions. Eliminating the Prevention and Public Health Fund would seriously undermine the ability of states and territories to respond to Zika and other infectious disease threats. And I urge my colleagues to support this amendment. But if you're looking at the amendments, you can see that we have a whole bunch of other amendments on particular illnesses. But this is to make the point that the Prevention and Health Fund is used for so many things, and one that we can't respond to, like Zika immediately. The funds are there for the Centers for Disease Control to deal with it and help our states respond to it. And I yield back my time.
Gentleman yields back. Chair would recognize the gentleman from Pennsylvania, Mr. Pitts.
Thank you, Mr. Chairman. I rise to oppose a Green amendment. A strong epidemiological laboratory capacity is crucial in identifying and diagnosis for emerging infectious diseases. However, it is not appropriate, as the amendment does, to place this burden on every state and local health office. It is inappropriate to ask states that are at no risk for localized transmission of the Zika virus due to the lack of the Aedes aegypti mosquito in much of northwestern United States to divert their time, money in preparing for a virus that may never meaningfully impact their constituency. The focus should be on bolstering regional centers of excellence in addressing Zika. It would be unwise to use federal dollars to build Zika capacity in every state and every local lab. We don't need a permanent multi-billion-dollar fund that can be used by HHS Secretary for any purpose that the Secretary deems appropriate. And as I said before, the Prevention Slush Fund is a great example of Congress abdicating its duty to set priorities. It's time that we reassert the role of Congress in setting fiscal priorities. So I urge my colleagues to oppose this amendment.
Gentleman yields back. Other members wish? Gentleman from Kentucky, Mr. Yarmouth.
Move strike the last word, and I yield my time to Mr. Green.
Thank you, Mr. Chairman. And my chairman of the Health Subcommittee, if we don't have this fund, it will be forced onto the state health departments. Without the partnership of the CDC, those epidemiological labs will be forced on our states, particularly in a state like Texas. If you look at the map where the Zika virus is going to happen, it will include most of the southern states and even up to some northern states. But without adopting this amendment, and if this bill passes and becomes law, it will force it on all our states to be able to deal with it themselves without having a partnership with the CDC. And with that, that's why this amendment is so important for a current disease that we're having trouble tracking in our own country, much less worldwide. Thank you for yielding to me.
Yeah, I yield back, Mr. Chairman.
Gentleman yield back. Roll call is requested. Those in favor will say aye. Opposed say no. Clerk will call the roll.
Mr. Barton. Mr. Whitfield. Mr. Whitfield votes no. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Walden votes no. Mr. Murphy. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilrakis. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Ms. Eshoo votes aye. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGette. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Mr. Doyle votes aye. Ms. Schakowsky. Ms. Schakowsky votes aye. Mr. Butterfield. Mr. Butterfield votes aye. Ms. Matsui. Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch. Mr. Lujan. Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Lobzak. Mr. Lobzak votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman Upton votes no.
How does Mr. Harper vote?
Mr. Harper votes no.
Mr. Barton?
Mr. Barton votes no.
Mr. Bilrakis?
Mr. Bilrakis votes no.
Other members wishing to cast a vote? Seeing none, the clerk will report the tally.
Yes.
I voted no.
Mr. Chairman, on that vote, there were 19 ayes and 26 noes.
19 ayes, 26 noes. The amendment is not agreed to. Are there further amendments to the bill?
Chairman, I have an amendment.
Gentleman from New Mexico has an amendment. The clerk will report the title of the amendment.
MD 10. Youth Suicide Prevention Program.
Amendment to H.R. 4725, offered by Mr. Lujan.
The amendment will be considered read. The staff will distribute the amendment, and the gentleman is recognized for 5 minutes in support of his amendment.
Mr. Chairman, I'd like to visit with all of our colleagues about an important provision that's being stricken from this bill. But first off, to make clear that I strongly oppose the repeal of the Prevention and Public Health Fund. The Prevention Fund provides vital resources to support state-run public health efforts to combat chronic diseases, lead poisoning, and suicide. In 2015, this fund provided more than $7 million to New Mexico. For the last several years, this committee has been working to improve mental health care in this country. Unfortunately, this bill undermines those efforts. According to the CDC, in 2014, there were nearly 43,000 suicides across our nation. For young Americans between the ages of 15 and 34, suicide remains the leading cause of death. Behind each of these numbers is a story of a family member, a friend, a loved one whose life ended far too soon. To combat this, Congress created the Garrett Lee Smith Suicide Prevention Programs. Last year, we provided $12 million to the Prevention and Public Health Fund to the Garrett Lee Smith Suicide Prevention Program to help states and tribes implement youth suicide prevention programs. This accounts for nearly a third of the total funding this program received. To date, the Garrett Lee Smith Suicide Prevention Program has awarded 180 grants to 50 states and the District of Columbia, 47 tribes or tribal organizations, and 1 territory. This includes a program to the Pueblo of San Felipe, which supports suicide prevention in New Mexico, which is working to develop and implement tribal youth programs. This also makes sure that early intervention programs are not left behind. The research shows that the Garrett Lee Smith suicide prevention efforts work. One study in the American Journal of Public Health showed that counties that have adopted this training have significantly lowered suicide rates among young people. Another study reported that an expansion of the program would have prevented more than 79,000 suicide attempts. Let me repeat that last one. Another study reported that an expansion of the program would have prevented more than 79,000 suicide attempts. So I hope when we have a conversation about this that there's not a mention of this being a slush fund or a gimmick, because 79,000 lives is real and meaningful. Just one is, as we look at this important program. And we shouldn't forget that this was brought to us in 2004 after the passing of a son of one of our colleagues, Senator Smith out of Oregon. I hope that there's some support in this regard not to cut this program, not to reduce this program by an additional $12 million. And that's why I'm offering an amendment to protect the prevention fund from any cuts to the Garrett Lee Smith Youth Suicide Prevention Program, which does also receive some funding from another area. So I hope that an excuse is not given to suggest that more funds come into this program through another aspect of the budget, which is $24 million. It's currently at $36 million. This was authorized for $82 million in 2004, signed by President Bush, where the Congress came together to do the right thing. So I'm hopeful we'll do the right thing today and protect this program. And with that, Mr. Chairman, I yield back the balance of my time.
Gentleman yields back. Chair would recognize gentleman from Virginia, Mr. Griffith.
Thank you, Mr. Chairman. I urge my colleagues to oppose the amendment. Republicans support the Garrett Lee Smith Youth Suicide Prevention Program. As the gentleman said, it came into existence in 2004, long before the slush fund came into existence. We have funded this program through the appropriations process. The question before us today is whether a permanent, multi-billion-dollar mandatory fund is necessary. The appropriations process is the place where Congress is supposed to set its fiscal priorities. I think the Garrett Lee Smith program is one that the appropriators should prioritize when making choices. This program supports things such as campus suicide prevention programs, which are important in assisting colleges in preventing the tragedy of suicide on their campuses. An important program such as this enjoys broad bipartisan support, and it will not go unfunded by our appropriations colleagues. Responsible governing is about setting priorities. An open-ended slush fund is not responsible governing. If Congress does not set priorities, programs like the Garrett Lee Smith program will suffer as mandatory programs, and interest on the debt continue to take a bigger piece of the budget. The bill before us includes common sense reforms like ensuring lottery winners don't take advantage of Medicaid and disabled children aren't treated worse than incarcerated individuals under Medicaid. It is time that we take our heads out of the sand and acknowledge that it is things like this $2 billion a year permanent slush fund that add to the fiscal troubles of our country. We are passing down a fiscal mess to our children and our grandchildren. I urge my colleagues to vote no on this amendment, and I yield back.
Gentleman yields back. I just want to, before I yield, I just want to note, it's my understanding that we're likely to have only 3 more amendments left before we get the final passage. So, Chair will recognize Mr. Cardenas.
Thank you, Mr. Chairman. Thank you for holding this hearing. But it disturbs me when my colleagues, my elected colleagues, start using terms like slush fund without getting into the detail of fact, and then when we have other colleagues pointing out the cause and effect of making policy that forces good programs to close under the guise of efficiency or getting rid of slush funds or what have you. And I think that Mr. Lujan very eloquently pointed out how important some of this funding is when it comes to literally saving American lives, especially when it comes to the fact that today we've sent more Americans than we have in the last decades, more Americans to go fight in our American uniforms, and they've come back in many cases not the same. I dare say feeling broken and having a suicide rate that's higher than any other demographic in our country. So making sure that we are there for them and their families is critically important. And with all due respect, the term of Congress has the power of the purse. You're darn right. When we cut into that purse, we must not forget that many times we're doing so to the detriment of services and to the livelihoods of individuals and families here in America. And with that, I'd like to yield the balance of my time to my colleague Lujan. With your permission, Mr. Chair.
My concern is when I agree that we as members of Congress need to take our heads out of the sand. 43,000 suicides across the nation in 2014 for young adults between the ages of 15 and 34. Suicide remains the second leading cause of death. That's profound. And when this program was authorized for $82 million, what's being suggested today is to reduce it from $36 million, which is already half, a little more than half of $82 million, to $24. I'm at a loss of words, Mr. Chairman. So as we look at this budget debate with what's before us today, this notion that the way that we cover children with S-chip is by cutting a program, by helping kids that are vulnerable to suicide and mental behavioral health is by cutting the program. I'm just sorry that we're even having to vote on this legislation today, because I know this is not easy for anyone, especially anyone that's opposing these programs and cutting them. I just hope, Mr. Chairman, that there is a better way to get to this, but cutting these programs is not a way to help these children, especially when another report suggests additional support saves an additional 79,000 young people. So with that, I yield back the balance of my time back to Mr. Cardenas. I see Mr. Sarbanes is looking for time, Mr. Cardenas.
Gentleman yield. I want to thank Congressman Lujan for bringing this dictionary today, because it's going to come in handy now. The first definition of slush fund is a fund raised from the sale of slush and other refuse to obtain small luxuries or pleasures. And the second one is a fund for bribing public officials. I don't see how we can characterize this prevention fund as a slush fund when it's going to combat suicide and suicide attempts, as Mr. Lujan has described. That is not a luxury. It's not a luxury to combat suicide in this country. That's a necessity I would think all of us could agree on. So you can argue against this fund, but to characterize it as a slush fund when it's addressing these important priorities, I think is unfair and irresponsible, and I yield back to the gentleman from California.
Thank you, Mr. Chairman.
Gentleman yields back. The gentleman from Pennsylvania, Dr. Murphy.
Thank you. I want to point out that Garrett Lee Smith bill has not been reauthorized since 2006, so it's been 10 years. Last year, there's 41,000 deaths by suicide in this country, 1.2 million suicide attempts serious enough to require medical care. We don't even know how many were attempted that didn't require medical care, and 45,000 drug overdose deaths, and the list goes on and on. An article appeared, I think it was in today's Washington Post, about a man last name Ford, age 22, who went to attack some policemen with the idea that he wanted to be killed. So it was an attempted suicide by cop. These stories go on and on, all throughout the nation. And again, looking at where we put money and some things doesn't deal with this whole issue. We need comprehensive reform. And I know the gentleman's concerned about this. We all are. But I ask again, that if we do this only in terms of some aspects of looking for funding, I will work with the gentleman. I will sign a letter with them to ask the appropriators, heck, we should get everybody in this committee to sign it, to ask for money for Garrett Lee Smith. But when it comes to actually making a change in this, I just hope to God this committee looks at how we can do comprehensive reform, because people who are committing suicide are troubled, many times seriously mentally ill or depressed or have other problems. And we need to get to the underlying cause of all this and really address it. And I hope, again, that's something this committee will deal with soon.
The gentleman yield.
I'll yield to the gentleman from Illinois.
Thank you. Remember what this is. This is a $2 billion a year self-appropriating fund under Obamacare that we don't control. It never goes through the appropriation process.
This one did.
Just that portion of it, but not not this whole fund. This is giving HHS $2 billion unaccountable every year without going through the appropriation committee. That's what we're addressing. We're appropriators. We authorize and then we appropriate. That's our responsibilities. And for slush, we've listed the slush: pickleball, massage therapy, kickboxing, kayaking, Zumba, bike lanes, free pet neutering, urban gardening, lobbying for a soda tax, block constructions of new job-creating fast food small businesses, boosting bike clubs. Come on. $2 billion every year under Obamacare that we don't control. And we authorize, and our appropriators are supposed to appropriate. If this is a good enough fund, then the authorizer should continue to authorize, and the appropriator should appropriate the money. Don't put a guilt trip on us when we're just trying to do our job. And if it's a good enough program, authorize it and appropriate. Don't give it to HHS to run amok, spread their money out under Obamacare. I yield back.
Would the gentleman yield? I don't know. I think this is Murphy's time.
Murphy's.
I'll yield to the gentleman.
The appropriators actually do appropriate all the money under the prevention fund. I mean, that's a fact. So I don't know what the gentleman's talking about. They actually do appropriate the money. They review it and they appropriate the money. They may not like what they do, but that is the case.
Would the gentleman yield?
Yes, I'll yield.
They're not required to go through the appropriation process under Obamacare law.
Well, whether they're required or not, the fact of the matter is that they do it, and they did
But
it
several years they have not.
last fiscal year.
But they have not in the past.
Look, again, I don't know. We keep talking about this. This prevention fund was set up for exactly that, prevention. I don't think you can argue that overwhelmingly the money is not used for prevention, and it is essentially appropriated by the appropriators annually. So I don't know, what the point you're trying to make. And you keep mentioning all these other things. We're talking about suicide. We're talking about lead prevention. We're talking about Zika. We're talking about very important issues here. And the whole purpose of the prevention fund, when it was established by the Affordable Care Act, was for exactly that, prevention. And you may argue and say, okay, Zumba or whatever isn't prevention, but the fact of the matter is, as Mr. Green points out, I know we're all kidding here, that it does have an important purpose for people who are suffering from diabetes. So, you can argue what you think is good or bad. The fact of the matter is,
just reclaiming my last few seconds here, if I could, for my friend. It's just, I want to get back to the original issue. Let's deal with this mental illness as a serious issue that this committee ought to be handling comprehensively. I yield back.
Gentleman's time has expired. I think we're ready to vote on this amendment. Gentlelady from New York is recognized.
Thank you, Mr. Chairman. I'd like to yield time to Mr. Lujan.
Thank you, Ms. Clark. I'm glad that this is an evenly charged debate. Because people, you guys will less than deserves that. Why we should vote for my amendment. To my colleague, Mr. Schimpf, look, I don't, who's in the majority. The majority, our Republican colleagues, have the votes to pass the legislation that's before us today. All my amendment is saying is don't take the money away from the suicide prevention program. That's all that my amendment does. My amendment, look, I certainly hope that slush fund, when we talk about a slush fund and the litany of issues that some colleagues have characterized as a slush fund, what I heard today during this debate on this amendment is that suicide prevention is now part of that. That's not right. And so let's just pause, think about this one, and see what we can do to protect this 12 million, which, if I could ask a parliamentary inquiry to council, isn't it true that the F-2000 appropriate bill passed by this Congress allocated every dollar of the prevention fund, including the $12 million for the Garrett Lee Smith Youth Suicide Program?
That is
With the gentleman, I join my colleague from Pennsylvania in a letter to the appropriators, as he offered, so that regular order would occur and we'd have this funded.
Ms. Clark?
Yes, I yield to Mr. Lujan.
Mr. Chairman, if I could ask General Counsel, are we going through regular order today?
This is a full committee markup, yes.
Regular order, right? Last time I watched one of those reruns of the School of Rock cartoons, this is what it took me through. Regular order through the committee process. This is more profound than a letter. We're voting today whether we're going to keep this program alive or this program goes away. That's more powerful than a letter. We have this right now. Why strike it? Why eliminate it? And so, Mr. Chairman, just again, as we work on this one, I hope that, again, the Garrett Lee Smith Youth Suicide Prevention Program, we all we all agree in protecting this program. Let's just work together not to eliminate this $12 million, which will reduce it even more. And by the power of a vote today, by voting yes on this amendment, we can do that. I yield back.
Mr. Chairman, I yield time to Mr. Cardenas.
Thank you very much. Basically, ladies and gentlemen, what we're witnessing right now is the legislative two-step. It's when legislation is passed not as an appropriation legislation, but as an act of Congress to implement, whether it's to negate something or to enact a new program or effort. Basically, what we're watching is a policy committee making legislation and then therefore making it easier for the appropriators to go ahead and say, let's follow the legislation that was passed in the policy committee and let's cut the suicide prevention money. Because that's in line with what our policy committee has already done. So I want to thank Mr. Lujan for his amendment, but also for his unwillingness to look at the clock and be deterred from continuing to make this important life-saving point, even though we're all keeping ourselves from our lunch. It's really important that we understand that as legislators, we should be willing to sacrifice our time, other things that we may want to do, so that we can actually get things right, because that's what the millions of voters send the handful of us here to do, and that is to get it right. Tens of thousands of American children, men and women, are killing themselves at their own hand every year, and we just have a modicum of funds. For us to cut it is atrocious. Thank you. I back.
Expired. Mr. Field. Whitfield. Jimkus. Jimkus votes no. Mr. Pitt. Mr. Pitts votes no. Mr. Murphy votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Latta. Mr. Latta votes no. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley. Mr. McKinley votes no. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Griffith. Mr. Griffith votes no. Mr. Bilrakis. Mr. Bilrakis votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks? Mrs. Brooks votes no. Mr. Mullen? Mr. Hudson? Mr. Hudson?
Mr. Mullen vote and then?
Mr. Mullen votes no. Mr. Collins? No. Votes no. Mr. Pallone? Mr. Pallone votes aye. Mr. Green votes aye. Ms. Capps? Ms. Capps votes aye. Mr. Doyle? Mr. Doyle votes aye. Ms. Schakowsky? Schakowsky votes aye. Mr. Butterfield votes aye. Matsui? Matsui votes aye. Ms. Castor? Ms. Castor votes aye. Mr. Sarbanes? Mr. Sarbanes votes aye. Mr. McNerney? Mr. McNerney votes aye. Mr. Welch? Mr. Mr. Todd aye. Mr. Yarmouth votes aye. Mr. Clark votes aye. Mr. Lopes? Mr. Aye. Mr. Kim votes aye. Mr. Cardenas? Mr. Cardenas votes aye. Chairman Upton?
Votes no.
Chairman Upton votes no.
Was Mr. recorded? Did you call me? No, yeah, I asked.
Mr. Barton votes no.
Mr. Scalise?
No. Mr. Scalise votes no.
Other members?
Mr. Chairman, on that vote, there were 20 ayes and 27 noes.
20 ayes, 2 noes. The amendment is not further. None. Oh, is the amendment at desk?
Amendment.
Clerk will put the title of the amendment.
What's the number, sir?
That's. I see the header. 01.
AMD 01.
Amendment to H.R. 4725, offered by Mr. Butterfield.
The amendment will be considered as read. The staff will distribute the amendment, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. Mr. Chairman, we are facing a public health crisis in our country. We certainly all know that. It's happening because of our country's aging water and sewer infrastructure. The epicenter of this crisis is the city of Flint, Michigan, where more than 10,000 children, many under the age of 6, have been exposed to lead in their drinking water. Dangerous exposure in a series of lifelong development and learning abilities. The crisis is not limited. It impacts the entire country. The New York Times reported that the city of Sebring found unsafe levels of lead in their water. It did more than 5 months before instructing pregnant women and children to stop drinking the water. In my district in North Carolina, the cities of Durham and Greenville have had tap water with unsafe levels of lead. Earlier this month, I sent a letter to the appropriate agency in North Carolina requesting a comprehensive review of the water systems. I have serious concerns with this entire bill, but I am particularly concerned with Section 6 of the bill. Section 6 repeals Section 4002 of the ACA, which is the Prevention and Public Health Fund, and rescinds all unobligated funds. This fund was created to provide for expanded and sustained national investment in prevention and public health programs to improve health and help restrain the rate of growth in private and public sector health care costs. This amendment, Mr. Chairman, supports public health by requiring the Secretary of HHS to certify that in repealing the Prevention and Public Health Fund, that there exists no risk to lead exposure to humans from sources of lead in pipes or soil or paint anywhere in our country. We all know the risk of lead exposure, and I mentioned them earlier. It's critical that should the Prevention and Public Health Fund be repealed, as is called for in Section 6, the American people should receive assurances that in doing so, there exists no risk of lead exposure to humans from paint, pipes, or soil. And so, Mr. Chairman, I'm totally opposed to the repeal of this fund because of the good it's doing all across the country. I ask my colleagues to join with me in supporting this amendment.
Can
I yield back.
the gentleman yield?
I will yield to the ranking member.
Thank you. I just want to say that this is a very important amendment. Unfortunately, it took the crisis in Flint to awaken the national conscience to the threat that lead poses to human health, particularly for children. And just last week, just to highlight how many communities are impacted, it's not just Flint. Just last week, bottled water had to be delivered to 30 school district buildings in Newark, New Jersey, because testing showed that those schools' drinking water had elevated levels of lead. We had also a report that 11 cities in New Jersey have a higher proportion of young children with dangerous levels of lead exposure than Flint, Michigan. I think there's an urgent need for more rather than fewer federal dollars for lead poisoning prevention. The fact of the matter is that the Prevention Fund provides all of the funding for the CDC's childhood lead poisoning prevention. So if this bill were to become law without Mr. Butterfield's amendment, there would be no money for the CDC's childhood lead poisoning prevention. So I urge my colleagues to support this amendment, and not important than making sure that lead poisoning, particularly for children.
Will the gentleman?
Sure, let's do Butterfield's time.
Well, you're both. I understand to go by voice down, but I'm forwarding with everyone here kind of solution for. Pass something the next day or two in the Senate. We can then work on in the House. But I would urge.
Thank you, Mr. That's very reassuring. I've read your comments about the Flint
I
crisis.
care about it.
I've
All of our communities.
Yes, and I thank you for that, and I look forward to working with you as we address the lead problem, not only in Flint, but all across the country. Thank you.
That.
I yield back.
And you gentleman yields back.
Yes.
And with that, I think we can have a vote on the amendment offered by someone from North Carolina. Those in favor say aye.
Aye.
Those opposed say no. No. Opinion share. Those have amendment is not agreed to. Are there further amendments to the bill? Gentlelady from New York.
Thank you, Mr. Chairman. I rise to offer my amendment.
Clerk, order the title of the amendment.
It's Clark 10015, excuse me.
Clark 015.
Yes.
Amendment to H.R. 4725, offered by Ms. Clark of New York.
And without objection, the amendment is considered as read. The staff will distribute the amendment, and the gentlelady has 5 minutes in support of her amendment.
Thank you so very much, Mr. Chairman. My amendment protects funding for the racial and ethnic approaches to community health program, also known as REACH. This amendment would exclude the program from the language set forth in the section of the bill. REACH is a program to reduce racial and ethnic health disparities. Through REACH, awardees plan and carry out local culturally appropriate programs to address a wide range of racial and ethnic minorities. Health disparities are glaring. One particularly tragic disparity is in infant mortality rate. Infant mortality is defined as the death of his or her. African American infants have a national infant mortality rate of 10.84%, twice the infant mortality of their white counterparts. How groups have produced positive outcomes for ethnic minorities. In Brownsville, Brooklyn, which is a predominantly African-American neighborhood located in my district in New York, REACH funded a local nonprofit, the Brooklyn Perinatal Network, and its program. This local community health center implementation of an enhanced perinatal risk assessment system and a community action system to link women with services. These efforts were aimed at identifying at-risk mothers and in doing so, connect them with the appropriate services to lower their baby's risk of infant mortality. Because of this program, half of the rest connect to additional support services to aid in the healthy delivery and support of their babies. I found it absolutely astonishing that my Republican colleagues who claim to be so concerned about saving the life of a child, but yet they consistently attack programs such as REACH that are actually saving children's lives by lowering infant mortality rates in communities of color. So one person's slush fund is another person's access to life itself. It's plain and simple. Either you're on the side of saving lives of infants or you're not. All of those in favor of saving infants, vote in favor of my amendment, and I yield back the balance of my time.
Gentlelady yields back. Other members wishing to speak on the amendment? Seen none. The vote occurs on the amendment offered by the gentlelady from New York. All those in favor? Do you want a roll call? Roll call vote is requested. Clerk will call the roll.
Mr. Barton. Mr. Whitfield. Mr. Shimkus. Mr. Shimkus votes no. Mr. Pitts. Mr. Pitts votes no. Mr. Walden. Mr. Fee. Fee votes no. Mr. Burgess. Mr. Burgess votes no. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes no. Mr. Latta. Vote no. Mrs. Rogers. Mrs. McMorris Rogers votes no. Mr. Harper. Mr. Harper votes no. Mr. Lance. Mr. Lance votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. McKinley votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinder votes no. Mr. Griffith. Mr. Griffith votes Rackus. Mr. Bill Rackus votes no. Mr. Johnson. Mr. Johnson votes no. Mr. Long. Mr. Long votes no. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes no. Mr. Flores. Mr. Flores votes no. Mrs. Brooks. Mrs. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Mr. Hudson. Mr. Hudson votes no. Mr. Collins. Mr. Collins votes no. Mr. Kramer. Mr. Kramer votes no. Mr. Pallone votes aye. Mr. Rush. Ms. Eshoo. Mr. Engel. Mr. Green. Mr. Green votes aye. Ms. DeGale. No. Ms. Capps. Ms. Capps votes aye. Mr. Doyle. Yes. Mr. Doyle votes aye. Ms. Schakowsky.
Aye.
Ms. Schakowsky votes aye. Mr. Butterfield.
Aye.
Mr. Butterfield votes aye. Ms. Matsui.
Aye.
Ms. Matsui votes aye. Ms. Castor. Ms. Castor votes aye. Mr. Sarbanes. Mr. Sarbanes votes aye. Mr. McNerney. Mr. McNerney votes aye. Mr. Welch.
Because all those lights are on.
Mr. Lujan.
I heard the buzzer a minute ago.
Mr. Lujan votes aye. Mr. Tonko. Mr. Tonko votes aye. Mr. Yarmouth. Mr. Yarmouth votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Lobsack. Mr. Lobsack votes aye. Mr. Schrader. Mr. Schrader votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Chairman Upton.
Votes no.
Chairman.
Other members, Mr. Whitfield. Mr. Barton.
Mr. Barton votes no.
Did you get Mr. Whitfield as a no?
Mr. Whitfield votes no.
Mr. Walden. Any other members
Walden
wishing to cast
votes
a
no.
vote? Seeing none, clerk will report the tally.
Mr. Chairman, on that vote, there were 18 ayes and 29 noes.
18 ayes, 29 noes. The amendment is not agreed to. Chair would recognize Mr. Green for a UC.
Thank you, Mr. Chairman. I ask unanimous consent to place in the record a number of letters and from various groups, and ask unanimous consent to place them in the record.
Without objection, Chair would recognize Mr. Cardenas for an amendment.
Mr. Chairman, I have an amendment at the desk, and if allowed to speak on my amendment, I'm prepared to withdraw it after.
Oh, wonderful. Clerk will report the title of the amendment. Yeah.
Amendment to H.R. 4725.
It's my understanding this is the last amendment. So the amendment will be considered as read. The staff will distribute the amendment. The gentleman is recognized for as much time as he may consume.
They called votes, so I won't take too much time. Thank you, Mr. Chairman. My amendment would emphasize the importance of comprehensive immigration reform and its relevance in any serious discussions that must take place when considering mandatory spending cuts and savings and the effects of the budgetary decisions and actions by this committee. Arguably, the contours and effects of the Common Sense Savings Act stretch beyond the jurisdiction of our committee, yet a good deal of it is within the jurisdiction of the Energy and Commerce Committee. This bill and other so-called mandatory savings bills from at least 2 other House committees will be folded into the budget reconciliation process. The Republican Party claims that these pathways will result in specific savings in fiscal years 17 and 18 of about $12 billion and close to $300 billion over the next 10 years. Mr. Chairman, my amendment is germane to this because the fundamental purpose of the Common Sense Savings Act matches up with the fundamental purpose of my amendment, which is to reduce the federal deficit through spending reforms to public health programs by taking positive impacts of the comprehensive immigration reform on our revenue. If Congress is serious about reducing the federal budget, deficit through policy bills, then we should consider serious legislation that would actually increase our revenue and reduce the deficit. And once again, so we would not have to harm the health and effect that we have on our policy when it comes to vulnerable populations across America. Our nation doesn't win when we pass legislation that takes critically needed health care benefits from our most vulnerable and voiceless constituents, including low-income children, or even from low-income households that may be fortunate to prevail in a lawsuit and get a few damages. What Republicans prioritize and how they would go about cutting spending growth and the overall federal deficit probably diverges greatly from how most Americans would go about accomplishing those goals. Yet, what my amendment proposes could make a big long-term difference in reducing the federal deficit, would also allow us to continue to have the good programs that many people on both sides of the aisle agree that we should continue if we have the resources to do so. That being the case, ladies and gentlemen, comprehensive immigration reform would restore hundreds of billions of dollars to our revenue in this country at the federal level and also at local and state levels as well, and eventually, over the next 20 years, restore as much as $1 trillion, ladies and gentlemen, to the federal coffers, and that would allow us to continue to have the good programs that many of us believe in without having to make the difficult decisions of having to cut badly needed programs that save lives, improve the health of Americans, and also in addition to things like making sure that we are there for our constituents when it comes to mental health as well. Once again, ladies and gentlemen, we are in a policy committee, but when we actually get involved in making sure that we pass good, strong policy, it allows our appropriation committees, the other committees, to not have to make those draconian cuts that we force them to do when we make bad decisions at the legislative level, such as this wonderful policy committee. And with that, Mr. Chairman, I appreciate the opportunity to present my amendment, and I withdraw my amendment.
Gentleman withdraws his amendment. Votes have been called on the House floor. The chair would recognize the gentlelady from New York.
Remainder of my time, yes.
I appreciate it, Mr. Chairman. I'd just like to support my colleagues' amendment. 9 in 10 entrepreneurs recognize our immigration system is broken, and 3/4 support a pathway to citizenship for the 11.7 million unauthorized immigrants living in the country. Entrepreneurs also see the importance of legally admitting high and low-skilled immigrants to the United States. 74% of them believe it would be beneficial to the country and the economy to allow more high-skilled foreign workers to immigrate to the United States, and 64% believe we should admit more low-skilled workers. Legalizing unauthorized immigrants will increase the wages of American workers by $470 billion cumulatively over the next decade. Workers will spend these wages on goods and services, and this increased spending will drive businesses' demand and create prosperity. All told, legalizing the undocumented will create 121,000 jobs each year and add a cumulative $832 billion to the United States economy over the next decade. Mr. Chairman, indeed, if this amendment were to be adopted and we were to pass comprehensive immigration reform, these draconian cuts that are being proposed by my colleagues on the other side of the aisle would not be necessary. I yield back the balance of my time.
Gentleman's time has expired. Gentleman withdraws his amendment.
I withdraw my amendment. Thank you, Mr. Chairman.
Are there further amendments to the bill? Seeing none, question now occurs on favorably reporting H.R. 4725 to the House. Roll call is requested. Clerk will call the roll.
Mr. Barton. Mr. Barton votes aye. Mr. Whitfield. Mr. Whitfield votes aye. Mr. Shimkus. Mr. Shimkus votes aye. Mr. Pitts. Mr. Pitts votes aye. Mr. Walden. Mr. Walden votes aye. Mr. Murphy. Mr. Murphy votes aye. Mr. Burgess. Mr. Burgess votes aye. Mrs. Blackburn. Mr. Scalise. Mr. Scalise votes aye. Mr. Latta. Mr. Latta votes aye. Mrs. McMorris Rogers. Mrs. McMorris Rogers votes aye. Mr. Harper. Mr. Lance. Mr. Lance votes aye. Mr. Guthrie. Mr. Guthrie votes aye. Mr. Olson. Mr. Olson votes aye. Mr. McKinley. Mr. McKinley votes aye. Mr. Pompeo. Mr. Pompeo votes aye. Mr. Kinzinger. Mr. Kinzinger votes aye. Mr. Griffith. Mr. Griffith votes aye. Mr. Bilrakis. Mr. Bilrakis votes aye. Mr. Johnson. Mr. Long. Mr. Long votes aye. Mrs. Elmers. Mr. Bouchon. Mr. Bouchon votes aye. Mr. Flores. Mr. Flores votes aye. Mrs. Brooks. Mrs. Brooks votes aye. Mr. Mullen. Mr. Mullen votes aye. Mr. Hudson. Mr. Hudson votes aye. Mr. Collins. Mr. Collins votes aye. Mr. Kramer. Mr. Kramer votes aye. Mr. Pallone. Mr. Pallone votes no. Mr. Rush. Ms. Eshue. Mr. Engel. Mr. Green. Mr. Green votes no. Ms. DeGette. Ms. Capps. Ms. Capps votes no. Mr. Doyle. Mr. Doyle votes no. Ms. Schakowsky. Ms. Schakowsky votes no. Mr. Butterfield. Mr. Butterfield votes no. Ms. Matsui. Ms. Matsui votes no. Ms. Castor. Ms. Castor votes no. Mr. Sarbanes. Mr. Sarbanes votes no. Mr. McNerney. Mr. McNerney votes no. Mr. Welch. Mr. Welch votes no. Mr. Lujan. Mr. Lujan votes no. Mr. Tonko. Mr. Tonko votes no. Mr. Yarmouth. Mr. Yarmouth votes no. Ms. Clark. Ms. Clark votes no. Mr. Loebsack. Mr. Loebsack votes no. Mr. Schrader. Mr. Schrader votes no. Mr. Kennedy. Mr. Kennedy votes no. Mr. Cardenas.
Mr. Cardenas.
Mr. Cardenas votes no. Chairman Upton.
Votes aye.
Chairman Upton votes
Other
aye.
members wishing to cast a vote, Mr. Johnson.
Mr. Johnson votes aye.
Any other members wishing to cast a vote? Seeing none, the clerk will report the tally. Yeah.
Mr. Chairman, on that vote, there were 28 ayes and 19 noes.
28 ayes, 19 noes. The bill is approved, favorably reported. It would ask unanimous consent to make clerk make technical corrections to errors that may be in the bill. And without objections ordered, with that, committee stands adjourned.
So I'll see you on the floor.
See you on the floor.